It's 7:29. I now call the East Lyme Zoning Commission regular meeting on March 7th, 2024 to order at 7:30 p.m. If we could all stand and say the Pledge of Allegiance. Public delegations is the time when members of the public are invited to speak to the commission on items that are not on the agenda. And I think there's been some confusion about that maybe the past couple months. It's come to my attention that maybe the end of last year some of the members were given copies of bylaws that weren't the most recent. So I'm going to hand out the most recent copies of our bylaws that were filed 4/27/23, where it states that public delegations are for items not on the agenda. So, if anybody needs a copy. Is there anyone here in the public that would like to speak tonight? Yes, sir.
How are you guys?
If you could state your name and address, please.
All right, so my name is Eric Vilcek. I live at 4 Meadow Street. I'm a full-time student at Connecticut College in New London. So I'd like to express my grave concerns over the potential development over the Trackus property that overlooks Dodge Pond right next to my house. I grew up enjoying the serenity and quietness of this town, and I feel that this development would be a pollution of this green space. Moreover, I think this kind of building threatens the pollinator pathway, as well as Dodge Pond's place in the Niantic wetlands. I cannot imagine how the development of over 400 living units, a movie theater, and shopping center is worth the desecration of this landmark of natural beauty and environmental resource. I understand the town is trying to adhere to the state statute 8-30, but I can't help but feel like the town is being captured by these land developers who are only interested in their own profits and not the well-being of our town. Thank you.
Thank you. Is there anyone here that wants to speak to something that is not on tonight's agenda? Yes, ma'am.
Hi, Lisa McGowan, 33 Spinnaker. I feel like I'm boring myself for being here. I was going to wear the same outfit that I've worn every single time since October to remind Ms. Thurlow that, yes, you lost by either 41 votes, and I really don't think it's funny. I don't know why you think it's funny. It makes me a little sick to my stomach to think that you think it's funny. But anyway, that's on the record again. People watch the video, they watch the tape. So again, I'm sorry that you think that's really funny. But I did want to go over tonight. I happen to sit on the Youth Services Board, and I just got sworn in just the other day. And I have an ethics code. I don't know if everybody sees that. If you all up there need to be reminded of it, I can highlight certain passages for everybody, but I just did get sworn in. And I just wanted to remind people on the board that they have, there are some realtors on the board. I know that you know who they are. I can call you out, but I don't think I want to. But the personal, beneficial interest, any interest other than financial, but then you also have conflict of interest. A person governed by this code shall not engage in or participate in any business or transaction, nor have an interest, direct or indirect, which is incompatible with the proper discharge of his or her official duties in the public interest, or would tend to impair his or her independent judgment or action in the performance of his or her official duties. So I wanted to speak to that and just remind the board and the public and whoever's going to watch on TV. And I also wanted to speak to the party that, I don't know if he's here, the party that asked Dr. Paivo to recuse himself. So this is under Clause B, notwithstanding the provision in Division A/2/A above, a town official, officer, or employee may vote or otherwise participate in a matter if it involves a determination of general policy and the interest is shared with a substantial segment of the town population. So again, the math up there is a little suspect with Mrs. Thurlow sitting in the chair seat. So I just did want to remind all the citizens that we do have a voice, and our voice was a little thwarted. But I'm going to come to every single meeting, even if I had to leave another meeting to be here. So thank you for letting me speak.
Sure, thank you. Anyone else tonight? Okay, I think we can move on to the roll call. I'm here, Mr. Peck.
Yep.
Ms. Markovitz. Mr. Foley.
Yes.
Ms. Kalal.
Yes.
Mr. Pivo.
Yes, ma'am.
And Ms. Susko. You're here? Thank you. I believe Ms. Uhas is on vacation this week. Unfortunately, Mr. Mulholland is under the weather. We all hope he's feeling better soon. And Ms. LaRocco is here. Thank you so much. And also, not to forget our ex officio. I believe I saw Ms. Hardy. Thank you. We have a public hearing tonight. And I'd like to note that Attorney Carey is here representing our town. It is for the application of Kristen Clark, P.E., for conceptual site plan approval per Connecticut General Statute 830G, affordable housing of a 25-unit age-restricted single and multifamily affordable residential housing development to be located on the northerly side of Boston Post Road on a parcel identified as 91 Boston Post Road, Assessor Map 31.0, Lot 2. We do have some memos to read first, if that's, or would you like to? Oh, okay. We were going to read some memos first, if that's okay, or do you want to have?
I'm here to help.
Okay.
As deemed necessary.
Oh, thank you. We appreciate that.
Can I ask a quick question before you read memos?
Sure.
Just so I'm trying to understand the context of this a little bit, which might help me to understand the memos as I'm listening to them. And this is kind of a question for you, Mr. Carey. I'm glad you're here. What's a conceptual site plan? What is our responsibility with respect to this? Are we supposed to be approving it? And if so, what's the implications of approving or denying? You get my question. I'm trying to understand.
Frankly, those are questions I was going to put to the applicant.
I see.
They filed an application for a conceptual site plan that they say is filed under Section 8-30G of the statute. By that, I believe they're disclaiming filing under your regulation.
That's another question.
Your regulation, I don't think, has a category for conceptual site plans. Three different site plans, none of them are conceptual, if I remember correctly. The regulation expressly states that there's no constructible project until a final site plan is approved. I believe the applicant said, represented in materials that I've seen, that I think are in front of the commission, that they're looking for a conceptual site plan to sign off as to whether this is generally an appropriate site for affordable housing, but not for a detailed approval of a permit that would be qualified for a zoning permit or for building permits. I'd ask them to lay it out for us if they would, but I was confused as well.
All right.
Okay, thank you. Okay.
Yeah, sort of.
First, we have an engineering memo. Would you like to read that one?
Sure.
Okay, you've got it.
Okay. March 5th, 2024, 3 Latimer Green, 91 Boston Post Road, proposed age-restricted affordable housing development conceptual site plan approval review. Mr. Mulholland, as requested, I have reviewed the materials submitted by the applicant and their engineers and attorney regarding the proposed development at 91 Boston Post Road in support of a conceptual site plan approval. These materials include a letter from Paul Garrity, Esquire, dated January 17, 2024, with an exhibit package, including a site plan prepared by engineer Timothy May, P.E., dated January 15, 2024, and a traffic report prepared engineer Kristen Clark P.E., PTOE, dated January 14, 2024. I also received another letter from Attorney Garrity Esquire dated February 27, 2024, with a stormwater management evaluation prepared by engineer Timothy May, P.E., dated February 26, 2024. After the review of the materials, I provide the following comments. 1. I note that a portion of the retaining wall and septic systems appear to be proposed in the AE flood zone. 2. I note that the development proposes a private driveway. Private driveway will not receive public works services such as snow removal, stormwater management, systems maintenance, pavement repair, preservation, and refuse collection. I recommend any operations and maintenance plan be submitted that clearly outlines responsible parties for future management of these critical functions. Respectfully, Alex Close, P.E., Town Engineer.
The second memo is from Mr. Gary Gaishel, Director of Planning. I'd like to note it is a 6-page memo, single line typed. My suggestion would be we continue this hearing and take these things home and read them instead of reading all 6 pages tonight. And if that's, it will be in the record, so anybody can come in and read it from the town. Do I have a consensus that that would be okay?
Absolutely.
Okay, so we'll
Mr. Carey is.
yes.
I agree with you. I have no objection to what I think what you just suggested is appropriate. The date of the continued hearing now is important. It can't be a long time.
I believe we were going to call a meeting for next Thursday. Thank you. The third memo we have is a water and sewer memo. Would you like to read that, or do you want to share? Or?
No, I can read it.
Okay.
Is that this one?
Mm-hmm.
Okay. From Ben North, sent March 6, 2024, 11:48 a.m. through Jessica LaRocco, Bill Mulholland, Septic 91 Boston Post Road, Latimer Green Development. Mr. Mulholland, realizing that this is a conceptual plan and I have not been provided with any proposed water and sewer designs, I have some initial comments in regards to the proposed development at 91 Boston Post Road. Town water supply is available in accordance with the concepts development, which I understand to consist of 12 duplex residences of 2 bedrooms each, 12 apartments with 2 bedrooms each, and single-family home of 3 bedrooms each. Using East Lyme water and sewer regulations, I assume this equates to an average daily water demand of 7,650 gallons per day for domestic usage, which does not include water for lawn irrigation or fire protection requirements. There is also an East Lyme water and sewer regulation, to my recollection, that developments requesting lawn irrigation provided via their own water supply from private wells on site designed for that purpose. The developer has not requested any additional water for lawn irrigation. The developer will be required to tie into the end of the existing town distribution system at a size to be determined by the East Lyme Water Department and tee into the proposed development with a water main sufficient capacity to provide for fire protection from hydrants and other conferring with the East Lyme Building Department sprinkler protection in some of the units. This system shall be metered at the initial entrance of the property with a master meter. It will be up to the owner to decide to meter the individual units, but as this is an apartment development with a single owner, East Lyme Water and Sewer will not be requiring or providing sub-metering. The master meter water mains and all associated water appurtenances will be provided by, owned, and maintained by the development and considered a private system, but will be constructed in accordance with the East Lyme Water and Sewer Protection specifications approved by the East Lyme Water and Sewer before construction commences. Final use of the system will follow successful inspection and testing of the water system before water is approved for connection. Water assessments will be owed to the East Lyme Water and Sewer for the main connection to the development as well as the individual connections to the units. A fee schedule will be developed based on the connection size per East Lyme Water and Sewer ordinances concerning water assessments and benefit assessments if applicable. The developer had sent a letter on 2/26/24 to inquire about the possibility of sewer connection to the town's sewer system. The developer owner would need to seek capacity from the East Lyme Water Sewer Commission, as the development is large enough to fall under the sewer capacity regulations developed by the commission to review the sewer and sewer capacity sought. The commission would hold a public hearing on the development and determine, based on East Lyme Water and Sewer criteria, whether sufficient sewer capacity exists to allow the project to connect. If the capacity is granted, the developer would bear the cost of connecting to the existing town sewer system at a size to be determined by the East Lyme Sewer Department, and tee into the proposed development with a sewer main of sufficient capacity. A sewer assessment would be levied against the development and all connections to the sewer, including sewer mains, all appurtenances, and would be owned and maintained by the property owner and constructed in accordance with the East Lyme Water and Sewer specifications and approved by the East Lyme and Water Sewer before construction commences. Final use of the system will follow successful inspection and testing of the sewer system before the sewer's approved connection, if capacity is granted. A disclaimer that both water and sewer infrastructure within the bounds of the property would be considered a private systems shall be included on any site plan to be submitted for review. There are some of my initial comments and are subject to change or to be revised based on further information and details provided by the developer as this project progresses from a concept to a proposed design. Thank you. Ben North, Chief Operating Officer, East Lyme Water and Sewer.
And there's just one left. I think you'll appreciate this one.
Oh, yes. From Eric Quinn to Jessica Lorato, subject 91 Boston Post Road, conceptual. Good morning. The apartment will need a hydrant within 100 feet of the apartment buildings. Eric.
Thank you. I believe Attorney Garrity is here to speak for the applicant.
Yes. Good evening, ladies and gentlemen of the commission. I have a number of housekeeping matters before we get started, but seeing as how I understand that you would like to do some light reading, I also have some homework for you that I'll hand out in a minute. What I'd like to do is hand out initially copies so everybody has one, and Mr. May, that's his presentation.
Is this already in the exhibit list, or is this something you'd like to add?
That is, I don't know if that particular version is in the exhibit list,
So
so
we'll
I would add it,
Oh,
just to be
thank you.
sure.
Okay.
Light reading, I see.
At least it's big.
I'll also
I
provide
appreciate that.
some binders that are
Even bigger.
contain the information, some of which I'm going to go over tonight.
Thank you. Are we going to get started straight soon?
That's
I need them.
In light of the fact that Mr. Mulholland is not here tonight, I assume Ms. LaRocco will be getting the documents.
Yes.
So I have the mailings, or certificates of mailings for the hearing. Also would like to make part of the record the minutes from the February 1st, 2024 Zoning Commission meeting, minutes from the February 15th, 2024 Zoning Commission meeting, minutes from the January 18th, 2024 meeting, the 2024 approved agenda for the hearings scheduled, the regular meetings scheduled for this commission, and also an article from the New London Day regarding pending lawsuit, because I think that's going to come up during this presentation, but regarding my client's application up on Walnut Hill Road. I want to start by addressing the Commission's decision to commence this as a public hearing. One of the issues, and I've raised this with Attorney Carey, in terms of this, was the fact that this has been scheduled as a public hearing, and it is our position that the scheduling of this as a public hearing was done procedurally improperly or illegally, however you want to phrase that, in that when this was on the February 1st hearing, Mr. Mulholland indicated, and I have the video here, which I'll play in a second, it's only a few seconds, indicated that, he said to Madam Chair, schedule this for a hearing, and Madam Chair said, yes, public hearing. No vote was taken on that, and we believe that that is a fatal procedural defect in this. We also believe, and again, this is something I've raised with Attorney Carey, that by scheduling a conceptual site plan application for a public hearing imposes an undue and unlawful burden on my client, which is not permitted by the statute, because you have now invited the public to come in and comment on an application for site plan approval on a conceptual basis. And the standards, to get to one of the issues Mr. Pivo was raising, for a conceptual site plan are very, very different than what is required for a final site plan. We fully understand that if this commission approves a conceptual plan, we have to go through the entire process and start to finish in order to demonstrate that every other aspect of the town's zoning regulations, health code, inland wetlands, and all can be satisfied to the to those commissions before we can even put a shovel in the ground, so to speak. And what I would like to do then at this point is to just play that so the commission members, I don't know if everybody was on this, but it starts. Mr. Mulholland say schedule that?
I believe.
So you can see from that there was no vote or discussion as to holding a public hearing on it. And what concerns us about that is because generally when you have schedule something for a public hearing is because there is a significant public interest in it. And I recognize the fact that the public has an interest in this application, but that interest doesn't come into play at this particular point in time. Because again, it's a conceptual site plan, and I should point out that we met with staff earlier this week, and that included meeting with Mr. Geishel, Mr. Mulholland, the fire marshal, just looking for my notes here of all the folks that were there, Bill Bundy, the fire marshal, Bill Scher, the town engineer, or the acting town engineer, Mr. Geishel, Mr. Mulholland, as I said, Joe Bragaw of Public Works, Ben North of Water and Sewer, and David Garside of Building. And the purpose of that meeting, which we had requested, was to get preliminary input from them on the project so that we could understand what concerns that they would have going forward in the event the conceptual site plan is approved. And that allows us to determine whether or not there are obstacles that we're going to have to clear, that we can clear or can't clear, or do we need to redesign it? And this gets into the very fundamental concept of a conceptual site plan. The conceptual site plan is, as I said, a streamlined process whereby the commission would look at the proposal, and I would submit to you that what we have submitted is more than what's required under the requirements for a conceptual site plan, nonetheless. But it doesn't change the fact that we're here. So the issue, one of the issues before you is this under your regulations or under 830G? This is under 830G. However, Mr. Carey is wrong when he says you don't have a conceptual aspect in there. In your regulations, I have a moment here. Section 32, that is your affordable housing plan or regulations. And in section 32.9, it refers to an application for a designation as affordable housing district may be initiated in 3 ways: conceptual site plan, application for a preliminary site plan, or a final site plan. We're coming in under the general statutes because your regulation talks about conceptual and zone changes, and the Superior Court has already found that you can't link the two. This particular town, the court found against that, saying you cannot link a conceptual site plan with a zone change because 830G allows you to look at anywhere in town and point to that and say we can do a conceptual site plan and an affordable housing project there. In addition to the limited nature of a conceptual site plan, what I'd like to provide, and Mr. Peter, I think this will answer some of your questions too, are copies of a memorandum that I prepared as part of this. And the memorandum explains in it what the rules are for conceptual site plans. It explains what the burden of this commission is in making a decision. And as I think most of the members know, that in terms that the burden of proof is reversed in affordable housing appeals, or excuse me, in affordable housing applications, and appeals for that matter though. In this particular case, if the commission were to deny this application for a conceptual site plan, it needs to not simply say that it's concerned about things, it must find evidence in the record that rises to a point that that points to a necessary and protected public interest, such as safety or fire or something along those lines. But not just that you're concerned about that, that is more probable than not that something adverse would occur in one of those categories if you approve the application. So it's a very high burden, and there's a reason for that, because the state legislature has recognized that local zoning has been a way to exclude from almost every town in the state affordable housing by citing to things that have traditionally been grounds for denying subdivision applications or other developments. So I'd like to hand out my memo.
Thank you. You can.
And with respect to this memo, what this is essentially plagiarized from the Connecticut Land Use Practice book. You'll see in here the references in the Connecticut Land Use Practice. And Tim, could you give Attorney Carey a copy of that too?
Yeah. Sorry.
I'm sorry, yeah. So it goes through what the burden of proof is, and then it goes through those things you may not consider as part of an affordable housing application in that. And it also establishes your burden on here. So let me go over what I see as the important parts for purposes of this particular hearing. The Commission cannot deny an affordable housing application unless there is a quantifiable probability of harm from the defect or problem with the application, not merely the possibility of harm to the public interest, and that reasonable changes cannot be made to the application to address the problem. That's one of the things behind the conceptual site plan application. If you see issues with it, you're to alert us to those issues so that we can try and address them. And that was the reason for meeting with staff, to understand what they saw as issues going forward, so that we could say, hey, we will try and address these things. And I will give you a for instance. One of the issues was the location of lights within the project itself and the type of lights that they wanted within the project. However, the fire marshal said, maybe I want you to make a tweak to this area at the top of that. And the issue there is then, okay, if we do that, then we have to move all the lights. We don't want to design where all those lights are going to go until we know where everybody is on board with these things. Because, again, and repeat, I don't want to sound like a broken record, but, you know, been through this enough, particularly with this town in terms of some of the applications, to know that this, I have to drive this home. I have no choice but to drive this home. And it is that you can't tell us or deny us simply because you say it's not the right location. We think there's a traffic issue. All those things, when you look through the memo, you're going to find aren't something that you can consider at this point in time. And a lot of them you can't consider at all, even when we come in with the final application. Because the courts have seen fit, and the legislature has seen fit to say, this is how commissions shoot down applications for affordable housing, and we're not going to allow it anymore. So let me go on. So the denial by inland, we don't need inland wetlands approval at this stage. There is a memo in the booklet that I handed out. It's Exhibit 11. It is an email from myself to Mr. Mulholland. It attached to it a letter from Edward O'Connell, the town's attorney, regarding whether or not a application that indicated it would impact the wetlands could be denied on that basis. And at that point in time, Mr. O'Connell's opinion, it's a letter from August 4th, 2005, indicated to the commission that no, not on a conceptual site plan, because this isn't anything that's going to get a permit to allow you to put a shovel in the ground. This is preliminary, it's conceptual, it's only there so that we can figure out what you think is of a concern to you and what we think we're obligated to do and whether we can address any of those concerns if they are in fact legitimate. In terms of the reports that you read tonight, we did have a chance to look through some of those, but in light of the fact that I only received them in writing, you know, we had asked staff and they said they would get them to us, so I understand that. But we got them yesterday afternoon, so even Mr. Gaishel's report I have not had a chance to thoroughly review. With respect to the reasoning for any decision here, I will read from, again, the Connecticut Land Use Practice Manual. The agency must first establish that the reasons for the agency's decisions are supported by sufficient evidence in the record. That is important because unless there is countervailing evidence to the applicant's application and the documents in there, there's no other evidence in the record that can be considered because there's no other evidence in the record. So the administrative record must establish that there is more than a mere theoretical possibility, but not necessarily a likelihood of a specific harm to the public, beyond a theoretical possibility. There must be evidence in the record that is quantifiable, of a quantifiable probability that a specific harm, not a generalized harm, will result if the application is granted, and mere concerns alone are insufficient. If the court finds that one or more of the agency's reasons are supported by the evidence, it then conducts a plenary review of the record and independently determines if the agency's decision was necessary to protect substantial interest in health, safety, or other matters that the agency can legally consider, whether the risk of such harm to the public clearly outweighs the need for affordable housing, and whether the public interest can be protected with reasonable changes to the affordable housing application or development. and I've cited some of the cases in there. In addition, there is the Landmark case, of which there are many, but as you're all well aware, Landmark involves this town and this commission. And this is the Landmark decision of September 18th, 2018. And it's Landmark versus East Lyme, and it's the land use docket CV 156064232. There's an opinion by Judge Berger, who was the land court judge. And I should point out for any of the commission members that think about the land court, something it's not necessarily really new, but it was created about 10 years ago with the idea that a single judge who had experience in these areas, or a couple of judges who had experience in these areas, would hear all affordable housing appeals in one judicial district, so there would be a uniform body of law that resulted from that. And Judge Berger, in his decision, in footnote 7, said, it's noted in 830G, the regulation may conflict in that the statute requires only a conceptual site plan, while the regulation requires a final site plan. That's, he was referring to your regulation. A conceptual site plan, and this is important to remember, is a site plan, is a common sense land use tool providing for stage planning and early review and the benefits of all parties by allowing for a determination of whether a proposed project is feasible without the expenditure of great sums of money by the developer and of substantial amounts and times of money by the town and town staff and volunteers, as well as the residents interested in reviewing the process. So the conceptual plan that we have submitted to you includes all that is required. Let me walk through the timeline here. The application was submitted on January 17th. The next regularly scheduled meeting was January 18th, making that the date of acceptance. That's important if you're going to continue this hearing, because one of the issues that I am going to point out tonight is that because this is a conceptual site plan, and it's a site plan, the fact that you may have done this as a public hearing does not give you any time to decide after you close the public hearing. You have 65 days from the date of receipt, and then when the public hearing is closed, then if you're not done within the 65 days, you have an inferred approval at that point.
May I ask, where's the 65 days in the statute? Is that in the zoning statute?
It's in the zoning statute,
code.
right.
That chapter, that paragraph doesn't refer to 830G. It refers specifically to several other sections in the state law. But when I looked at it, I was confused because I didn't see that it referred to 830G. So I wonder if that's been established as really applying to 830G applications.
Well, because
am I wrong? Am I right?
I don't think you're either, and I don't mean to avoid it. What it is it talks about site plans, right? So this comes in as a site plan. It's an 830G site plan, but it's a site plan, and that's the site plan, special permit, re-subdivision. Those are how the timelines are defined. So if it comes in as a site plan, doesn't matter that it's an affordable housing project or anything else, a subdivision or a re-subdivision, but a re-subdivision would automatically trigger.
But you said this was an application under 830G. Is that not true?
It is an 830G application being made as a conceptual site plan, which 830G allows.
Yeah, okay.
So when you go back to the time frame or the timelines for that, you go into site plans and it's 65 days no matter what, start to finish to decision, all within that window. No 35 days after you close the public hearing to render a decision.
And there will be time to question both attorneys after they both present. So, yeah.
I don't mean to argue about that, but it's hard to remember your questions when you wait till the very
can
end.
be. That's
So
true.
I noticed that judges ask questions of attorneys when they're testifying in court, interrupt them rudely to do so. So I thought maybe he wouldn't mind.
Only to object. We have to hold all the questions until it's our turn at that point. But I'm certainly willing to entertain questions as we go along.
Thank you.
make this part of the record too. This is,
Could I ask you a general question while you're shuffling this around? What, I guess what I keep wanting to ask you, and forgive me if this is too simple, but what is it that you hope to gain by this approval? I mean, there's very little cause that we can use to turn down an application. There's not enough details here for us to really dig into and determine if there's any adverse effect on health or safety. I guess I'm just puzzled about this whole process of a preliminary or conceptual plan. What is it that you hope to accomplish?
well, I think by virtue of your question, we've already accomplished part of what I was hoping, is that you would look at this and say, generally at a conceptual stage, if it meets those requirements, you're not going to deny it, you're going to grant us an approval, and then we know we can proceed to the next level of doing the detailed work that's required, because we will have to determine sewerage, water.
Yeah, I get all of that, but I mean, even if we were to vote no on this conceptual plan, you can proceed anyway with the project.
The difference is, and that's, as I read Judge Berger's decision, it is to come in and say, okay, this is the project we have. Do any of you, when you look at what's before you, and granted, it's not the final project, or what is there about this project that you look at that you can legitimately consider for a final approval that troubles you, if anything? And that way, so if we were to come in, and I'll use the landmark application because I monitored that over the years. They would come in, do a ton of work for 750 units, get shot down, take an appeal, come back in with 800 units or 650, redesign the whole project almost, redesign the roads, redesign the proposed septic and so forth. That cost a ton of money. It's incredibly expensive. And that's how projects get killed. And that's what the courts have recognized and the legislature has recognized. Projects die from 1,000 cuts because developers can no longer continue to afford what they're doing. And then they say, hang it up, or they go for something else. So what I'm expecting and hoping from this commission is that you will look at this project, because we've deemed it feasible, and I know that's not something you have to consider, but for us as a developer, we have to go in there and look and say, yeah, we can do it, it can be done. There may be some issues, but we can work with those issues. And so if you say, okay, what you see tonight is acceptable to you from a conceptual standpoint, and you have no issues with it, you give it your blessing, and we proceed. Then we have to meet with staff and so forth. Or you might say, you know what, we like this project, or it's from a conceptual standpoint, it's okay, but we got a couple of issues. We want you to try and address those issues if you can. So the whole point is, because once you file the application, and this is a sort of a downside to the process for zoning or things of that nature, is that you typically would come in and meet with staff, you get input from them, but on a affordable housing project, it's far more complicated than a subdivision, where you just make sure that you do you meet the subdivision requirements, and then the commission has no choice but to approve the application. In an affordable housing, because the statute allows you to pick anywhere in town, right? And there aren't necessarily specific design requirements for an affordable housing project like there are for subdivisions. Say you have a setback, you have to have your roads 25 feet, those kinds of things. There's a bit gray there. Now, we can look at your regulations for roads and lights and all that and design it, but we're trying to also understand what we should anticipate from you when we come in with the final application, as opposed to coming with a final application, having it denied, having to redo it and come back and so forth. This is, as the court said, it's a common sense means to get input back and forth, given the way the process is set up. I hope that answers your question.
It answers the question. It doesn't satisfy me, but that's all right.
I'm sorry, can I follow up on this
Sure.
question? It's a really important question he asked. I'm for conceptually collaborating, talking, working through ideas. I think that's a healthy, solid way to proceed with all development in town before you start spending a lot of money on design and planning and engineering and all the rest. What I'm really nervous about is the formality and all the judges and lawyers and court cases and everything else that's now you're talking to us about. Because what if we raise 3 issues tonight, and we say and you infer from that, other than those 3 issues, we're fine, but we have those issues, and then you proceed, and then you come back with a preliminary or final plan, and we say, oh well, we've now thought of another issue because we didn't think of it before, because new information has come to us. We've done some reading, we've done a site visit, and all the rest. Are we going to be constrained from raising other issues later on? It's this building of the record and the reliance on the record and us getting ourselves caught, in trouble that way, that really makes me very nervous. That's why I don't like the formality of this conversation. I'd much rather have it be informal collaboration.
And I would love that too, but unfortunately that's not the way our process works, and that's one of the reasons why we're putting everything in the record, because I don't want to, if you were to say no, and we've had that happen up on Walnut Hill, where the commission denied the application, and now we have to go to a judge, and the judge is going to say, well, where's this? Where's that? And so if it's not in the record, then the judge won't consider it. So that's one of the reasons for putting everything in the record, to say, look, we may or may not need that down the road. I don't necessarily know that I need some of that stuff tonight, but if the application is denied, I want the record to be complete. So
what real question is, when you come back for a final application, and there's a new traffic issue that I want to raise, and I didn't raise it tonight, or during this, will I be prevented from doing that?
You can raise it. The question will be whether or not it is a traffic issue that can be considered.
Assuming it's legal.
So, and this is a good question. I don't think I can answer that yay or nay tonight, or at all, because ultimately it'll be a judge who decides that. But I mean, if we go there, but if you were to come in and we say, okay, we've done this, no changes to this thing conceptually, right? Same number of units, let's say everything is generally substantially the same for the final plan once that. And then you said, oh, well, you know what? In this project, there's a left-hand turn. There's no left-hand turn. I don't like it. I'm going to vote against it. That would be a problem for you, because I don't think you could that. But if, for instance, traffic patterns changed between the conceptual thing on the road or entrance, or a area got blocked off, and you said, well, now this is an issue. Let's say it's on a state highway. State of Connecticut says, man, you know what? We're not going to grant you access anymore. And then you go, well, how do you get? We can't allow this, or we're only going to make you allow access in one direction. And you say, well, now that's changed. I think that it's frankly a bit of a gray area where a court might have to say, well, that wasn't before the commission then, and it's something that they ought to be able to consider. I don't know how a judge would rule on that, because ultimately it comes down to a judge is going to make that call. I mean, as between you and I'd say this to young lawyers all the time. I said, never argue with the other lawyer in court, because he ain't going to change his mind. Talk to the judge, right? And that is sort of here. I mean, you and I could look at this and say, all right, it did change. We don't think it's a significant change. You think it is a significant change. Now you're not in favor of the application anymore. How a judge decides that, if the application is then turned down, I honestly can't tell you. I wish I could, but predicting what another person will do in their interpretation of what the law would say. But again, the idea is that with the conceptual site plan, we provide what's required by the statute, and then we try and adhere to that conceptual plan, but address the issues like water, sewer, lighting, parking, all that within there to what the staff has an issue with, and go from there. But the other thing I would point out, and I don't think it's going to make you any happier, but there are very limited reasons for denying an affordable housing application when you actually look at it. Most of the ones that get turned down is because they have some significant issue that arises. We don't anticipate that here, frankly. I mean, it's a relatively small project, so, and as I said, having met with staff, I think most of the issues that they raised, and issues probably more of a negative term, most of the points that they brought up in terms of what they would be looking for, we can address. We know we can. So it was to say, like I said, the lights, you know, we're willing to do the type of lighting you want, just don't want to start drawing it on a thing if we have to make some changes before, you know, we get to the next step. I don't know. Okay. So there, in the package that was submitted as part of the application, and not that particular manual, there is a A2 survey, soils map. There's a traffic report. We do not believe we need a traffic report because this is in a commercial zone, although we did do a traffic report for this. I'd like to point out, too, that my client herself, Kristen Clark, is a, my notes here. She's a graduate of East Lyme High School, so, but she has a BS in engineering from the University of Virginia, master's degree in civil engineer from the University of Texas, in traffic planning and infrastructure. She's a licensed professional engineer in Connecticut for over 15 years, certified professional traffic operations engineer, and she's the one who prepared the traffic report. Representative past experience includes traffic planning for professional and college sports stadiums, including Dallas Cowboys, Atlanta Falcons, San Francisco 49ers, too bad, Baylor, and she's been an expert witness in numerous traffic cases. Mr. May, our engineer, is here tonight too, and he can read you his credentials or provide you with his credentials, but he's a licensed professional engineer. Joe Thoreau, who has done the wetlands report, he's a graduate of the University of Maine Forestry School. He's a certified professional soil scientist, professional forester, and the inland wetlands agent for a number of towns, up to 6 towns in eastern Connecticut. And I put that on the record just so that when everybody is looking at this and understanding who these people are, they have some sense of their weight or their gravitas. The other item I'd like to add into the agenda to follow up on a comment I had a moment ago is the August 4th, 2022 minutes from the East Lyme Zoning Commission, and I'll direct everyone to paragraph 3, subparagraph 1, in the second paragraph, and it's highlighted here, so when I give it to Madam Clerk, you'll be able to see it. But in that, Mr. Mulholland stated that the area is zoned commercial, so no traffic report is required. And I raise this by virtue of the fact to show you that we've gone well above and beyond what's required for a conceptual site plan, because we want to give to you the best example of what we can do, and not have you wondering about wetlands or not having you wondering about, you know, traffic impact, et cetera. A lot of the things that we met with staff are really, you know, it's the minutia almost in a way, and we believe that, you know, we can, as I said, address all of those particular items. So we've provided the zoning application, the A2 survey, the site plan soils map, traffic report, the building elevations, table describing the bedrooms and bathrooms, the affordability plan, a list of the required permits we will need, the design report. I get too many notebooks up here. There is my letter, which is Exhibit 10 in here, January 31st, 2024, to Mr. Mulholland regarding a request for review, which we did receive. Exhibit 11 is the fact that we are of the position we don't need to require, or we're not required at this time to obtain an inland wetlands permit. We understand we're going to have to go back. There are some wetlands on the property, but any work is outside. There's no work in the wetlands themselves, and any work that might occur is substantially outside the wetlands area. It's almost parallel or on the buffer line, but it's not anything that's going to have a negative impact. And Mr. Thoreau's report attests to that. My Exhibit 13 is my letter regarding our issue with the public hearing scheduled for this. There's a drainage report that's been provided as well by Mr. May, which he can go over. The other items are the staff reports. So if I can, I will go just. So, by way of background, the proposed Latimer Green housing development, which is what we're calling it, has been conceived and designed by English Harbor Capital Partners and Kristen Clark, who's a member of that, and professional engineer Tim May, who's here with me tonight. The intent is to address the lack of affordable housing in the town and the New London County region. The proposed development consists of one single-family home. I don't know how many of you are familiar with this property. There was a single-family house on it existing. The individual died. He had a reverse mortgage on it, and it was to be donated to the land trust, but they didn't have the money to pay off the mortgage on that and obtain title. My clients did so. As part of this, it's 11 acres, upwards of just, I think, shy of 9 acres is going to be essentially kept in open space. There's going to be an area as you get down towards Latimer Brook that is basically going to be just grass and left open so that it can connect with I think it's the New England forestry area behind it, so that has trails behind it as in between the power lines and whatever the development is on the backside of that off of 161. I want to call it 163, but it's 161, right? Yes. 163 is in Montville. And so that is the intent, is to donate that land either to the land trust or put a conservation easement on it in favor of the land trust so that there's no further development after these units go in. It's going to consist of six duplex homes, so a total of 12 units, and 12 single-floor apartments to be constructed on the 11.36 acres located at 91 Boston Post Road. It will be privately owned and maintained, so in other words, this is all going to be rental properties, and the developer of it will maintain and own everything, and that was one of the conversations we have with staff. We understand we'll have to make arrangements for maintenance, et cetera, as you know, we own it, but unlike subdivision where you might put conditions in deeds or restrictions in deeds, et cetera, or provisions for homeowners associations, that's not going to be the case here because it's intended to be developed and owned and then rented out. No public improvements are necessary at this point in time. The rental community is going to be age restricted, 55 plus. The map that's submitted to the Zoning Commission shows the location of development within the neighborhood. It shows its relationship to the subject property, to the natural and man-made features within 1,000 feet of the development site. It also includes topography, wetlands, woodlands, public roads, utility easements, and land protected under conservation. And that is all in the materials that's already been submitted. There's no endangered state or federal listed species or critical habitat that exist on the property. Based on the National Diversity Database area map. There are wetlands on the subject property, however, no new activity is proposed for any inland wetland or watercourse. The wetlands have been delineated on the A2 survey that Mr. May will go over with you shortly. The proposed development benefits by being adjacent to 200 acres. This is the New England Forestry Foundation of open space. This will be able to provide direct access from our property or my client's property to the existing trail system for passive recreation. In addition, a portion of the property is going to be utilized as a sod farm, and that's where I was talking about the lower area as you get down towards the Latimer Brook. That area is basically going to just be all grass. And that would be essentially on the western portion of the property.
Excuse me?
Yeah.
Did you say that that would be used as a sod farm?
That's one of the intents, yes, to use it as a sod farm at this point. So the land trust would hold the conservation easement on that area. I don't know if you're familiar with Weathersfield Meadows, which is a whole area down by the Connecticut River in Weathersfield, Rocky Hill. It's much larger. It's probably a few thousand acres if my guesstimate is close, but it has interior roads and they grow sod there. And it's frankly, it's used as floodplain. That's one of the reasons they grow sod there, because the river floods every year. So it provides a natural fertile soil base in order to grow sod.
By definition, a sod farm is a commercial property,
It's agricultural.
but it is a commercial application. Since you go in, strip off the sod, roll
Okay.
it up, and take it out.
All right, well, there's a point well taken then. So, I mean, that's the intent. This is why we're at a conceptual stage, so that we don't come in, we haven't made arrangements with that. That's one of the things we were looking at, because as we met with staff, one of the things they liked about that concept was that it acts as basically a sieve for surface water by retaining it, as opposed to a forested area that releases a lot more, or I shouldn't even say releases, it doesn't capture anywhere near the amount that a surface of grass would.
Except that in order to commercially farm that, you need to use herbicides and pesticides.
Not necessarily. I mean, and this is where we're getting a little bit far afield, right? You're asking me about pesticides, et cetera. All those things could be considered in there, and I hear what you're saying, you're raising it, so I'm taking mental note of it at this point to say, all right, maybe that's not the best thing. Maybe the best thing to do is just make it open space, clear it, or whatever, or leave it in its natural state. I mean, the intent that we have right now, so we can, I think, I don't want to speak off the cuff for my client, but we're able to be flexible because we're not developing that anyway. It's too close to the wetlands or to the Latimer Brook. And that was one of the reasons when we designed this the way we did, is to stay away from that, to stay out of any material construction within none in the wetlands, period, and out of the buffer area as best we can. And you know, you've extended, but for the 300 foot, I don't think we'd have any issue with the wetlands buffer, but it does come up, I think, right up against the driveway area.
I was thinking the same thing. I just think it brings up a lot of other questions, like will there be commercial trucks coming in and out and people working there? And so it might bring up a host of other questions.
Listen, I appreciate those comments, because, you know, looking at this, saying the last thing we want to do is say, all right, fine, and then look at it and go, well, that is a problem. And maybe it's something like Mr. Peter would say, well, you didn't mention the sod farm at the initial application. Had we known that, that would be a non-starter. So this is the idea behind this meeting, is this, okay, you guys are telling us you got some issues with the sod farm for concerns over materials that may be used to grow. And so I can take that back to my client, and when we go back to the table and put our pens to paper and say, maybe this isn't the best idea right now. Do it different. So
Just out of curiosity, and this is probably outside our purview, but Latimer Brook is a particularly sensitive body of water. I think it's a trout management area, among other things. Have you been to DEP? I know you don't have to have done that in order to be here tonight, but that seems to be is going to be a significant issue.
Well, our drainage report and the wetlands report indicates that it's probably not, but certainly, you know, it's something I'm happy to discuss with my clients, because, you know.
I think you may find there's a whole other level of regulation when you get into the fisheries people at the state.
I know, I think Latimer is stocked, but I think it's stocked, I should say, below the falls.
Yeah, I'm talking about the wild brown, well,
Yeah.
we're getting into the weeds.
All right, no, but I
was curious if you
appreciate
looked
the
into it.
comment though, because it's
The sod farm or the development in general?
The development in general.
yeah.
Well, I'll address that.
Okay.
It's going to, as I indicated, it's going to be an internal road, and will be built in phases if it's approved by this commission. So we'll build, you know, as you go in first, as we build the units in and go back. we're talking about, and I don't want to get step too far on Tim's toes, but when we talk about the stormwater management plan, we're proposing rain gardens to capture the roof runoff. Easements, there's an easement for utilities that already exist on the property for AT&T. And that is about it in terms of the design report. I don't know if the commission has any other questions of me at this point in time. Otherwise, I'll turn it over to Mr. May.
I'll ask you a quick question.
Sure.
Would you have preferred, or would you prefer that there be no public hearing? That is, that this is just an informal conversation we're having to help guide your plan preparation and thinking?
Yeah, I keep wanting to ask that myself.
Well, so the answer to that is yes, because what I'm concerned about, and this is where I think that there's a procedural issue that rises to the burden, right? The public is going to get a chance when this comes in front to address comments. Now we're talking about the sense of, what do you want from us? What do we want from you? Kind of thing. Yeah. So it's more informal, and if we're forced to address comments from the public at this point in time, we could be all over the place not knowing what it is because we don't have a final plan at this point in time. So I would prefer that, and I should point out,
Works for me.
the Belanger case addressed this.
Can I just say, before you do that?
Yeah.
We represent the public, but the public also represents itself, and it's not
Right.
unusual for developers to hold a meeting with neighbors in the community to say, this is
Correct.
what we're thinking about, everybody. What do you think? And they'll bring up the same issues we're bringing up, I'm sure. But all I'm saying is don't be shy about letting the public give you their thoughts about what they're afraid of or want to see about your project.
Yeah.
You know, I understand you mostly care about our votes, but we care about
No,
their.
I do too. I mean, I've sat on commissions. I was chairman, Haddam Planning Commission for 12 years or something like that. And so I agree. And we're not happy to talk with the public. I just, for purposes of this hearing, because I don't want it to kind of get out of hand in a sense that we now have all these different issues that are raising, which may or may not even be something that we have to deal with the final plan. So let me point out to your comment, Mr. Pivo, the Belanger case, it's Belanger, 199 Westlaw 512669, dealt with exactly this issue. It said where the commission conducts a public hearing or schedules a public hearing where it didn't have to, it had discretion, we don't need to figure out, it can undo that and just conduct it as a hearing and wait till the appropriate time to conduct the public hearing. So if this commission were to say, all right, we schedule it as a public hearing, but we're going to treat it just as a hearing instead and go from there, you would be able to do that tonight on your own motion.
Would there be any procedural?
I'll leave that to your counsel.
I'm
Would you?
not familiar with this Belanger case. I did write Mr. Gary an email on February 28th where I cited Michael Ziska's what's legally required book. He's finally come out with a new edition.
Would you mind speaking in a microphone?
Go ahead.
Thank you.
Thank you.
At any rate.
And this is Attorney Carey.
Yes, thank you. February 28th, I wrote an email to Mr. Garrity on this question. I am not familiar with the Belanger case. I'd be glad to look at it. Frankly, I think it would be more trouble stopping a public hearing after it started than deciding not to have one in the first place. I cited Attorney Michael Ziska's handbook on Connecticut zoning law. It's called What's Legally Required, and he finally issued, I think it's the 8th revised edition. And at page 100, if I can find it, it wasn't even that long. It's called What's Legally Required. At page 110, note 92, he cites a case, which I left the book over there, but it basically says that sometimes a zoning commission or a planning commission is legally mandated to have a hearing. But that when it's not legally mandated, it can, out of its own grace, schedule a hearing. I'm a little, having more process rather than less seems to me an easier position to defend than saying there shouldn't be any process. We've now listened. This hearing started. It's about 20 of 8. It's about 20 of 9, and we still haven't heard a thing about the application. In terms, if there's some concern that this commission will be unduly persuaded by a motion or something like that coming from that might come from the public, I think the law is that the commission is presumed that it is presumed that the commission will act appropriately. I don't think there's any concerns that the commission will be unduly persuaded by irrelevant concerns by the public. In terms of the process that was used to schedule this hearing or to schedule this for a hearing, I'm not aware of there being any law that requires that there be a formal vote on it. I do know in my own experience, town staff, and not here, but town staff have scheduled hearings on applications that came in before. They scheduled a hearing to begin at the next meeting of a commission after it was received, without putting it in front of the commission to have a discussion whether there would be a hearing or the date of the hearing or anything like that. So I don't know that it's necessary that there be a vote, even if this was by grace. Sorry to take your time up on that. If I can, while I'm standing here, Mr. Garrity didn't suggest, he said, if this application isn't acted on within 65 days of its receipt, it's subject to a deemed approval, an inferred approval for non-action. I don't agree with that. I think the statute is pretty clear that when it says that when a site plan is the only thing left to be adjudicated by a zoning commission on a particular project, short of the issuance of building permits, then there can be a deemed approval for failure to act. I don't think the statute creating the inferred approvals for site plans was intended to apply to this. I don't think a conceptual site plan is a site plan for those purposes. That said, I urge you to complete your action on this thing within 65 days of the date of receipt so that there will be no issue about that. The fact that there's an argument that there's going to be an inferred approval, while at the same time there are repeated assurances that if this application is approved, it's simply a preliminary thing that will lead to the filing of a final site plan or something like that. I think those are contradictory positions, it seems to me. So I think to eliminate any possibility of an inferred approval, action should be taken within 65 days of the receipt. And scheduling the hearing doesn't change that, it seems to me. I had a few other notes, but I don't want to interrupt them. It's the applicant's case.
Can I ask you a quick question, though? This business of a public hearing, or we cancel it and it's just a, quote, regular hearing, does that affect the 65-day
No.
inferred argument in any way, shape, or form?
No.
It wouldn't.
No, because
does it also change what constitutes the record under an 830G appeal? In other words, if it's not a public hearing, it's not going to, whatever we discuss isn't part of the record that goes in front of a judge?
No, the record is everything that comes into this commission,
regardless
regardless of whether there's a hearing or not. I mean,
okay.
site plans generally do not, site plans, not conceptual site plans generally do not have public hearings. But I will tell you that from my own experience in Groton years ago, there was an application to build a super Walmart right across the street from the Walmart on Route 184. No public hearing was mandated for that, but the commission decided that it was in the interest of everyone to have a public hearing. I don't know if you're familiar with the facilities at Groton, but the hearing ended up being held in the town council chambers, and there were people outside in the hallways. The applicant in that case did not argue that there was some unfairness or something involved in having the public hearing. In fact, I think they would have recognized that as much input as could be obtained was a useful thing on that particular application. So those are my views on these few issues.
Thank you,
Thank you. And I do hope we can get to the meat of the presentation.
If you give me 2 minutes, and we will. And
Thank
I will
you.
say this so that maybe the commission has one less thing to consider. I would agree. Regardless whether it's a public hearing or just a hearing, the record is the record. It will be the same, the court will look at the same thing. It's not going to distinguish to saying, oh, you didn't do this because it was a public hearing. Sorry, guys. With respect to that. So, and just in regard to the Banninger, it says if the commission was not barred from abandoning its decision to hold a public hearing, was a formal vote, and this is the court is raising it as a question, a formal vote or action by the commission required to authorize such abandonment? Again, the court answers in the negative. Court's not going to impose such a procedural straitjacket on a commission, a group of lay people dealing with many complex issues. So you don't have to, if you just say we're going to treat it as a hearing, period, that's all you need to do at this point. And with that, I will turn it over to Mr. May.
Position this so you guys can see it. You have, just for clarity, or I can pass it around. So a couple of things I just wanted to get into. My name is Timothy May. I'm a registered professional engineer in the state of Connecticut. I live at 1297 Route 163, Oakdale, Connecticut. And my company is May Engineering LLC. Graduate of UConn, 1997. After spending 10 years in the Navy and submarines, I went to UConn, got my engineering degree, and I'm here today. So I've done a fair amount of work for Waterford and East Lyme and other towns, but particularly Jordan Cove, some of the water quality issues there, some Bintic surveys, some coring samples to help out there. The town of East Lyme, when I was working for Don Gerwick, I don't know if you remember him. Taught me a lot about water quality as I learned a lot of things in school. So I'm going to step away from the microphone and hopefully you can hear me okay. This particular picture, and I'm sorry it's an eye chart, but it shows the existing condition now. There's a residential home, roughly about, right at about 900 feet of gravel and paved road. Relatively steep slopes between 12 and 8 to 12%. Some ledge up at the top. And this line right here is the flood zone for the, it says here the 500-year storm, but I believe it's the 100-year storm. And that's the Zone X, Zone E, and that's what the tonnage I refer to. This squiggly line here is the base flood elevation. It's 46 feet. And just off this page up here near that subdivision of the street, and that's at 47. So it gives you an idea that the flood elevation is at 46, and it really should follow the 46 contour line to be more exact. And then I'll point that out in my design where that has some implications to the design impacts. This is Boston Post Road, and these lines right here are the wetlands delineation, and then you can see the thread of the Latimer Brook, which is the western property line, is the thread of the brook. So it's 11.36 acres. There's roughly 5 to 6 outbuildings, sheds, barns. So it's fairly well developed. And I did a post and existing and a proposed development drainage analysis. This kind of gives you an idea of where the property is located. You have Tri-Town Foods, the supermarket, and CVS. And just to point this out, their building is actually in the floodway. And I thought that was kind of interesting. And their whole parking lot is pretty much the 100-year flood zone. So none of this development that we're proposing today is in the flood zone. So put that in perspective. So this is a picture similar to what you have in your packet, and I'll be shifting over that in just a moment to talk about some of the. This right here is an application I put on top to delineate the drainage area. It's about 7.85 acres of the 11 acres parcel. This particular, we're not developing, but all the water drains for the most part down gradient to the existing road and out that way. It's untreated, which is not necessarily a problem. It's all wooded, but some interesting facts about woodlands, this time of year, the worst erosion happens in the wintertime. There's no leaves on the trees, water collects on the trees, they fall, and there's a lot of raindrop erosion this time of year, which contributes to a lot of sedimentation flow. There's a lot of rotting leaves, decaying leaves, whatever you want to say, and there's a lot of sediment that gets uplifted in these heavy rains like we've had the past couple of days. That all gets flushed down. Currently, it's just a residential home, and I'm going to introduce a few things to make that situation better moving forward with the 2023 Stormwater Drainage Manual, which I've been reading diligently. And I was actually part of the 2004 Stormwater Drainage Manual way back when, and so I learned that one. So it's kind of refreshing. I kind of like the new edition. This new Stormwater Management Quality Manual gives the designer and engineer tremendous amount of more tools to treat stormwater, which helps development. So I'll switch over to our packet. So looking at the development, you can see there's, when I laid this out, the first thing I looked at is where can I put stormwater for this site. I have steep slope, I have hydraulic or soil hydraulics B, and there's a few hydraulics D in this. Both soils have moderate to high infiltration, so it's a good candidate for infiltration devices and also for detention ponds. So with that in mind, I started laying out, we had an existing home, you can see that kind of in the middle of the page. I replicated the same along the driveway, except this would be a 22-foot wide paved road with a collection system, a curb collection system, and then an additional 500 feet of road or driveway and parking area for the apartments up to the east of the property. And those are benched ins. There'll be a lot of retaining walls to bench in these buildings. And then the next page, if you'll shift over to where it's got the green and the lavender colored shading area, that shows a bifurcation of the drainage that I'm going to be treating. The one in the lavender will have a small amount of collection system that will go into a swale and then into a little bit of retention there before it goes into the wetlands. And then same with the green area, those will all be collected up from the apartment area along the road, the parking area, and then be collected, and then it'll drop into the larger detention ponds. That was my initial concept, and then I started reading more into the stormwater collection, and I started, one of the projects I worked on in Stonington, where I could not put any stormwater onto the road, on the main town road there. So I looked into infiltration between catch basins, having infiltration trenches built into to take that. So just keep that in mind. I'm going to be discussing in more detail. So,
Mr. May, I'm sorry to interrupt, but in the spirit of a conceptual application, perhaps you could just do the broad strokes.
Sure. I'll do it right now then. So looking at the reason I wanted to talk about these are to show that the water quality volumes that the stormwater requires has to be met. And the concept of that is I've done the work beforehand to show that conceptually. So if you'll bear with me, I'll try to be as quick as I can, but it is an important feature. Storm water quality, I believe, is a really important concept that I think that everybody who cares about Latimer Brook needs to understand, that we've looked at that early on as a concept.
Are you using 1.3 inches for the water quality volume pursuant to the 2020, yeah.
Do you want to go to the next page, or do you want to keep going? Up at the top, I'll just go right to it. Water quality volume for 90% total suspended solids and pollutant reduction. The area is 7.8, which is those two areas I just showed you. Water quality rainfall is 1.3. The 2004 water quality use is 1. In 2023, it's increased to 1.3, and that encompasses 90% of all the rainfall events that will occur on this property. And why this is important is because this is not over a duration of time. This is an instantaneous rainfall, and it's considered what they call the first flush. It's to remove, it's to capture all that, I mentioned all the decayed leaves, all the animal feces, all the things that we don't normally think about, but those are pollutants that are detrimental, especially during the first flush. All the oil that's on the roads, all the car tire debris, all the stuff that's there. This model that they use it is there to indicate to take exactly 1 inch of water rainfall over 7, and I have to store it or retain it. So moving down, I have 12% post area development, and then the required retention volume for this project is 4,190 cubic feet. And what that equates to is that when I go to design those infiltration trenches that I was mentioning earlier, that comes up to roughly about 400 to 500 feet of infiltration trenches. So I'll move on to the next one because I think you guys want to move along. What's been incorporated in this plan is low intensity development was done I mentioned the first thing I did when I started putting my pen to paper on this was I looked at stormwater. I looked at stormwater quality, and I looked at the impacts of what the design would introduce and reduce those early on in the design and the conceptual design. Stormwater retention. It'll have infiltration trenches in between catch basins, and it'll also have stormwater detention ponds, and it'll have stormwater renovation devices. And those are the structural BMTs for those two things. Go to the next page, which shows the infiltration trench schematic. What's going to be incorporated into this design will be the 48-inch sumps with the hood, and then that'll go into an infiltration trench, preferably along the road, and that will remove that. Just that alone, without even going to the detention pond, that gives me my water quality retention for this project. And one of the that I didn't go into that I was asked to move on is before, a couple of things I wanted to discuss, but I can do it later on in the report, is I've already met the stormwater quality issues, and it's just a conceptual. I'm looking at, so when I actually go into design, there's already a lot of conservatism built into this. It'll be relatively easy to achieve to meet the water quality standards. And the following pages are some examples of infiltration trenches that will be used. And then the next page where it shows kind of a little garden curbside, and then it shows a picture that I took up in Norwich to show these are drainage devices. One's in the stormwater quality manual. Although I like it, it's pretty, it's probably impossible to maintain. But this one is in the dead of winter, it was a week ago up in Norwich. This is a stormwater device that used to treat stormwater, and you can see it's got sediment around it. You can visually see it needs to be clean, but it's working. It's taking out the stuff before it gets into anything. And then there'll be a deep sump down before to remove any more, and then this goes into an infiltration system. So this is a device and a system that can be used in this project that will benefit stormwater quality as well. And then the last page, I just showed a detention pond that has approximately 6,000 cubic feet of storage. And then on the south of the property towards the entrance is a stormwater renovation swale, a plunge pool level splitter before it goes into the Latimer Brook. So I know I kind of went through that quickly. I think you asked for an abbreviated version. and hopefully you have some questions for me about the concept, how we got there. Just want to say we met with staff last week. One of my biggest concerns was the drive and the fire. Mr. Quinn, the fire marshal, said this is a good design. I talked to Mr. Gaishel about the wetlands, and he says what he has, what he sees, he foresees getting a wetlands permit with the amount of impacts here, so it was a positive. I didn't see he's going to give it to me, he just said it looks adequate. So we went through all the different town staffs and they gave their opinion, and it, this is the reason why we have the conceptual design, is to get the buy-in early, to get it going. And all town meetings are formal meetings, just to let you know. Because I'm an elected official in Montville, I sit on the town council, and every meeting is important, and they're formal, and they have a tremendous amount of meaning and impact. But you have any questions for me?
Anybody?
Probably. But can I ask us a procedural question then? So are we now expected to tick off the issues we're concerned about for them to work on?
Right now, we have time to ask either attorney or the presenter any questions. Then we go to the public, and then we can vote to continue this until next week and keep the hearing open.
This time we could tick off issues and say, please consider these things. Okay, fine, yes.
I have a question.
Sure.
Everything looks good except the entryway scares me a bit. It's either very fast-moving traffic or there's a traffic jam
Right.
coming into Flanders Four Corners.
That's correct.
And it's quite a hill getting up into the property.
No, not this one. This one's not. It's a little bit of a slope, but it's not too bad. I was just in it, and I drove a, regular car, and it wasn't an issue. There is one down a little further down that's very steep.
Okay.
And I think that can be brought down a little bit to make it a little less steep if that's the case. I didn't see anything that was too dramatic, but it may be better to be up high so you can see down the road a little bit more. Sometimes having a perched view can aid in that. But Kristen Clark, the professional engineer, she wrote a report on this. What's the trip count on this? Six
per hour.
So if somebody has to wait to leave this area till there's the right time, I don't think it's, for 6 cars is that much to ask, leave when it's safe. I've been there several times and I hadn't have a problem. I wouldn't take a left-hand turn out of here.
Right, it's right turn only.
It would be right turn only, but it's not. The traffic's typically slowing down. It's posted 35, and it does. There is a 2-lane that goes to 1, and it's still fairly wide there. It hasn't fully gone down to 1 lane, so I didn't feel threatened when I was leaving there from getting hit.
What about heading north on the post
You
road?
would have to take a right out of here and then go down and then, take a...
going into the property. Can you take a left-hand turn?
I think you could, if you have enough visibility.
Does your plan include a left-hand turn for entry?
Right.
Okay.
If you've ever been in that area at around 4 o'clock in the afternoon, it's backed up past the highway. And also, there is a right-hand turn only coming out of the mini mall down there, which is widely ignored. And I expect that this one would be too. You can see the curb has been run over multiple times. So it's a huge concern, that.
Yeah, we put what's called a pork chop island in there, and that could be, more aggressive. That would force it to be a right. I don't think anybody's going to try to take a left out of here. If you had it positioned right. But a left coming, I guess going north, is it north? Or whatever.
And obviously, there's no other.
You do have enough, you can slow down, you can gauge the traffic, and there's other traffic that's turning into other areas that are doing the same thing.
And obviously, there's no secondary egress out of this site.
No.
That's it. In and out, that's it.
Right.
Right.
So if there were a blockage down there, you couldn't get an emergency vehicle up there.
That's true with a lot of places on there. If there was a, I mean,
Particularly true with that
but the
place.
people I think will let you in if you asked them, you know, they're,
Nicely.
yeah. I'm sure, I mean, I believe in humanity is still, that's some decency. But that's, you can say that, but there's a lot of places here in East Lyme that are that way.
There are.
And,
I wouldn't disagree. I don't know that we need one more.
yeah.
On traffic, did you want to ask more questions about traffic?
No, I think,
Okay. On that one traffic issue, the site, I'm wondering about the sight lines, sight distance. Do you know what anyway, that should be looked at.
It's already in there. It's in the report.
Oh, well, okay.
331 feet.
Yeah, we haven't read the report, so that'll be
Yeah,
good.
331 feet. It's been
Oh, it is?
established.
Okay.
Um,
All right.
and-
That's what I want to know. And that's, meets the standard.
Yeah, it's section 4 in the binder that I gave you.
Okay. Have to get to that.
Yeah, no, understood.
Can I ask a question about the concept for the whole project being elderly? Which is out of your bailiwick, probably.
Oh, yeah,
But-
I'm getting close.
All right, well, not you, but the resident. I'm just wondering why it has to be restricted to seniors. And I have a slightly selfish reason for that, not that I'd want to live there, even though I am a senior. It's just that we're incentivized by 830G when it comes to earning points for a certificate of completion, if you know what, under 830L, where you get a half a point for a senior unit, and you get 1.5 or 2 points, depending on the number of bedrooms, for every family unit, they call it. And so it's in our interest to build more of the latter, because we get more points, you see. You know, so anyway, I'm generally curious about why you've self-limited it to seniors. We're not necessarily saying that, but I'm just curious what the thing is.
And I haven't spoken with my client as to why they particularly picked that, but I can tell you, I think I know why, because it limits the traffic for the site, which you're on the Boston Post Road. You're not going to have school buses having to drive in or stop there. So the 55, and trust me, 55 ain't even close to being old, right? 67, and I'm looking back at 55 going, yeah, that was a different time. So when we look at it from a development standpoint, the impact traffic, your water, number of bedrooms that you would need, et cetera, that's part of what drives the 55 and older in there, because you're going to have less people living in there, so that's going to drive down your water consumption, which is going to make your septic, et cetera. And you have to design the units for that. So these are apartments. So it's like, okay, we can't design these for a family that has 2 or 3 kids, given the size of the units, et cetera, and also the fact that once you design, throw in an extra bathroom or whatever, you're bumping up your water usage, which affects your septic design, et cetera, and you go from there. So I believe that's the reason a lot of that this was taken into consideration.
I have just a quick question. If you had thought, it's right behind Tri-Town, have you looked at any kind of sidewalks to walk to the grocery store?
We had a discussion with staff about that. They would like to see them. It's the state highway. We don't control that. And off-site improvements, I mean, if we could, we would look at, I mean, we're certainly willing to examine the issue further.
There's no way, like, through the back, like...
Across the brook?
Yeah, I was just curious.
Yeah, the bridge is a difficult issue because the cabling for the guardrails and so forth is actually, they have an easement on our property, stated.
You're talking about the bridge across the brook.
Oh, well.
The brook. But he's right, there's an extensive guardrail, you have to look at a picture. It is a concept, it could probably be done. But we've got to do, and it's not our property. It's state property, and then it goes even further. It's another 250 feet to where the other sidewalk ends.
Yeah.
So it's kind of a request that we can't just say, sure.
Yeah.
So, you know.
It'd be awfully swell.
Yeah, we are going to examine it, but for feasibility, but you know, we
Yeah.
can see that there's some issues, like the state of Connecticut is just,
And I was also wondering, in lieu of that, the idea of a bridge, which makes everybody wonder.
And one thing I mentioned,
You know, but a path down, and then and a stairway down, so you have the trail amenity and the brookside amenity for the seniors, which would be lovely, right?
if you guarantee us a wetlands permit, then maybe we can.
so one of the things is,
Just kidding, yeah.
whenever you review the low impact development, the very first part of standard one of the water quality manual for 2023, it states that you should reduce the number of sidewalks, get those down, because it calls it. We have 800 feet of sidewalks, and it looks appealing, you know, it's gonna be lighted, all these things can add up to it. Now you got light, a little more light pollution, a little more this and that. I'm not opposed to it, I think great, but will it be used? You know, so I think maybe, in my opinion, having some, you know, trails for activities to walk down by the Latimer Brook. I don't know if everybody in this development would use the sidewalks to walk to the grocery store, but some might. I don't know, but I would think that we ought to look at the stormwater quality. It's more pavement, more maintenance during wintertime, things like that that could be problematic for somebody that's older, that's all.
I'd just like to say that one of the best arguments for this project is putting residential in adjacent to the Four Corners,
Synergy.
where you're creating those synergies for a walkable village district. And this is less than a quarter, maybe barely a quarter mile from the market if you walk from the old house down and down the street and back to the market. It is definitely a walkable distance, and like you say, they're only 57. And so, no, I think on a nice day you'll find people will definitely take advantage of that opportunity, especially if there's some an opportunity to enjoy the amenities along the way of the sidewalk and the views. So that's a good, I think, worth working on, thinking about, considering.
Definitely consider. Yeah.
Conceptually.
Right, there we go.
I believe the hallmarks of an affordable housing is availability of water, sewer, accessibility to bus lines, accessibility to grocery stores. And I'm sorry, I'm certainly not going to well, I'm old enough to qualify. I'm not walking down that driveway on the road to get to Tri-Town.
Not to contradict you, but affordable housing, and especially the 830G, was specifically designed with the median income of the community it's in. And it was specifically designed back in the 80s so that school teachers, municipal workers, emergency workers could literally afford a home in that community that they worked in. And they looked at areas like Western Connecticut where things were cost prohibitive, school teachers, so they came up with 830G, and nowhere did it say it's a requirement to be on public transportation or near those things. We're kind of merging low-income housing. Affordable housing is not low-income housing. Affordable housing is designed for a certain component. And because I remember when it first came out, I read it, and I reread it, and I reread it, and the thing was is so that, you know, there's people in your community that need to live in your community. And it's kind of like a version of workforce housing. You know, your school teacher, your fireman, your policeman.
But everybody here is retired. They're not school teachers, they're not firemen.
But they don't necessarily have to have public transportation as a requirement for affordable housing.
In fact, in the exhibit that I gave you that is from the Connecticut Land Use Practice, proximity to public transportation is not something the Commission can consider.
Well, my point, though, is that if somebody wants to walk to the grocery store, they have to walk on state property to get there. As traffic has to take a right-hand turn there, I think that's becoming a little dangerous.
Well, presumably they would stay in the travel lane, not on the shoulder or on the sidewalk.
But have you been there, you know, after 2 o'clock on a Sunday?
go home that way every single day of the week, and well, less so these days since I'm semi-retired. But,
Well, there is room for a
yeah.
sidewalk. There is room, but there will be some encumbrances, you know, with the state, and I can't guarantee the state would say yes.
Right.
Because it's physically off our property. Their property line's there. And so there is probably room to walk there, but we would have to go from there all the way down to,
And it may require modifications to the bridge from looking at how the guardrails and all that. So there, I mean, we can look at it. I'm just, you know, I'm not going to promise you that we would be able to do it because we don't control the property.
Are there any more questions to either attorney or the presenter?
Just one last question. So you're going to save the old house?
you know, what else
Yes.
is being saved.
Yeah. Actually, it's been cleaned up and so, at least getting weather tight, so to speak, right now. So,
Okay, so are we ready to go to
Mr.
the,
Pivo has.
I just want to, by the way, it's Pivo, just, it's okay, but it's Pivo.
Oh, I'm sorry.
Yeah, so another issue is this is a visually prominent hill. And so if you were to do, like I did, a Google Earth, the view shed analysis from the, a point that I'm approximating, and this is exaggerated because it doesn't take into account the presence of trees on the landscape. It's not that sophisticated. But anyway, that hill and the woodland on it is an aesthetically attractive, and I know you're going to say it's under 830G, we're not allowed to consider aesthetics, but I don't really care because you're trying to make us happy anyway.
Yeah.
That tree is, that hillside is a visually attractive backdrop that reminds everybody where we live in this village, that there's the woodlands and the forests and the farms and all the rest, here, right? So what I'd like you to explore is how to minimize the clear cutting of the woodland. And if I'm not mistaken, given the slope and given the trees, I think these houses are going to be behind the trees and not really visually prominent. I don't know, but this may require a little more care than the bulldozing of the forest to make everything clear and open and easy to develop.
It's not that, right now, if you were to drive there today, other than widening the road and adding these homes, there's already a tree line here. So I don't know if you'd even see these homes.
That's what I'm wondering about.
And
yes.
this one is perched up because it's up 15, 16
Yes.
feet. And it, but there would be areas to put landscaping and stuff, and it's really keeping the light down so it doesn't.
Keep the light down, build the homes with a material that is natural and colors that are natural and look like they're blending into the landscape. Preserve that woodland on the downslope below. I think that will make will be effective. All I want you to do is look at this from a landscape architectural point of view. Look at this from views off site. That's would be a real value. A demonstration of
unless you're on the roof of the grocery stores, you're probably not going to see it.
That's what I'd like to know. That's what I'd like to know.
okay.
And then one last thing, and that's pertaining to the low impact development that you clearly are interested in and working on. No, as you probably know, none of these best management practices for infiltration and detention and all the rest remove 100% of the pollutants, including the E. coli.
We're only required to do 90% by the standard.
When it comes to E. coli, if you get 75%, you're lucky. And E. coli is the water quality problem that is exceeding the state standards.
That's what I wanted to get into, and I was interested.
I know. So let me just finish my. Okay.
Because you just said something that needs to be. I'm not going to contradict you, but when you have a trench,
Yeah.
right, and when you do the 1.3 inch of water first flush,
Yeah.
I have created the water quality, or the required volume to contain that water.
Yeah.
4,100 or whatever, I had it in my report, 4,100 cubic feet of water.
Right.
That's going to be contained
Yeah.
in this. It's not going to be going to Latimer Brook.
It'll infiltrate into the
And then it'll
groundwater.
infiltrate. I have 48 hours to
Yeah.
infiltrate. So anything that's
No, I'm
whatever,
talking.
it's
Yeah, I'm
gonna
talking
be in
about
there.
the water, the quality of the water that it infiltrates. And then from there, it moves groundwater to the brook.
Now, once, the soil chemical demand will kill that instantly. There's so many microorganisms and things, all that stuff is taken care of naturally. That's the beauty of the infiltration. You get into the chemistry and the biota that's naturally living in the soil. All those things are consumed.
Okay, well, I'll bring the scientific papers that we can debate. For the record,
for now, can we please
no,
move on?
I just want to make the point I was trying to make.
Well, that's the reason they have these. That's the reason the stormwater quality manual has these in there, is to reduce all the
Reduce, yes.
90%. That's
I understand, but the most important thing is to try to prevent discharge from getting into those systems in the first place. And that's where the rain gardens, the rain barrels, the pervious pavers, if possible, and the rain gardens right below and up at and around the houses, rather than collecting everything and discharging it down into the main pools, becomes really valuable.
I think you missed the whole discussion.
We really don't have time for this discussion tonight, and we can continue till next week. I know you have other detailed points, but we still have a regular meeting to get done tonight. Does the public have any comments on this project? Yes, sir.
Yes, my name is Donald Danella, 24 Patagonia Drive, East Lyme. I'd like to mention that I'm a Board of Selectmen appointed member of the East Lyme Commission for the Conservation of Natural Resources, as well as the Nyack River Watershed Committee. The Nyack River Watershed Committee was formed under the auspices of the Connecticut Deep in 2011 through the Nyack River Watershed Protection Compact that was signed by the chief executives of the 4 watershed towns of East Lyme, Waterford, Salem, and Montville. We are an advisory committee seeking to implement the goals and recommendations of the recently updated Nyack River Watershed Protection Plan and to support and improve water quality in the Nyack River and its tributaries. And I would urge the developers to look for that watershed protection plan on our website or through Town Hall and use it to help further the designs. I would also like to note that I performed 10 years of water quality monitoring in Latimer Brook, at the Latimer Brook Dam and other locations within the watershed. So we know a lot about water quality in Nyack River, and I wrote a 100-plus page report that Mr. Geishel has a copy of. One of the reasons I want to speak tonight is that I saw that there was going to be a public hearing about this particular project, obviously of great interest to me because of its close proximity to the Latimer Brook and the upper reaches of the Nyack River. I also thought it was odd to have a public hearing because what am I to review before? Only what I could hear tonight was available to me. I could be wrong, but I went to the East Lyme website today and yesterday's zoning. You can see you have your agendas, you have your minutes, you have materials. Well, the agenda had the public hearing on it. I went to materials, unless I made a mistake, there was absolutely nothing for me to review. I don't think it's proper to have a public hearing regardless of whether it's a preliminary or a final site plan without the public being able to examine materials. I'm glad I came. I thought the applicant provided a lot of information. I would like to add that I personally witnessed several failures during developments of moderately to large projects in this town, including the North Brybrook development, Noble Gas, and in particular, where there was a failure to control sedimentation runoff during the construction, and we have photographic evidence of considerable amount of sediments going into the upper Nyack River from that project, and I hope that's not something that's going to happen at this project into Latimer Brook. I was glad to hear that there are plans to mitigate impacts of the impervious surfaces and have a state-of-the-art stormwater management practices, which we'll certainly try to review. And we certainly hope that they will incorporate more low-impact low-impact technologies for both site preparation and development. And I think we need to protect the existing vegetative and riparian buffers. And on that note, I was sort of taken aback to hear that a sod farm would be considered in this so-called grassy area near Latimer Brook. I agree with Commissioner Kalau that a sod farm is going to require pesticides, herbicides, and fertilizers. The last thing we need to put into the Niagara River is more nitrogen from fertilizers. And I would urge the Commission not to allow such a use. And I will certainly be bringing this up to Inland Wetlands Agency if they have any purview over this. I made some more notes. I'm glad that the applicant has requested and apparently received a natural diversity database report from the Connecticut Deep. That is something that the Conservation Commission in this town has been urging for these types of developments to do. I think it's another great form of protection for our natural resources, particularly for these listed species that are threatened or endangered. I would also urge caution for both developers and commissions to throw ideas out in the air at a meeting such as this. I saw this happen many years ago at the Connecticut Signing Council held a public hearing in this very room for the solar farm that's located in East Lyme off Walnut Hill Road. And I saw the developers just pop up and say, oh, we're going to have we'll build an educational facility, we'll have this, we'll make it 2 stories so you can have people can go up there and get a good view of this whole site. Well, someone at the public hearing brought up the fact that, well, are you going to be compliant with the Americans for Disability Act? Are you going to have an elevator in this building so people can go up to the 2nd floor that are people who might be handicapped can go up to the 2nd floor? And I immediately saw the 2 gentlemen from the solar company look at each other like, uh-oh, they caught us. I knew right then and there that this was a bunch of bull. And certainly, I don't believe to this day there's been any public educational facility on that site for anybody to go and see. So this idea about having a bridge over Latimer Brook so people can get to Tri-Town Plaza. I also do sampling of macroinvertebrates, part of a Connecticut Deep voluntary citizen science program behind, and we actually sample Latimer Brook behind the IJ Plaza. Well, first of all, you should know that there is a very large, high chain link fence behind most of the plaza. Secondly, where there isn't one, closer to the Boston Post Road, there is one heck of a lush growth of poison ivy there for most of spring and summer. I would not want to put anybody across there on a bridge. I'll also say about a bridge, it sounds good. I'm also on the board of directors for the Friends of Oswegatchie Hills Nature Reserve, and we put that very fine wooden bridge in there a few years ago, allowing access to the blue trails. That bridge cost $35,000, and it did not include almost all the labor that we did ourselves, in assembling and painting and putting the footings in. So to put a bridge across a brook, and this Latimer Brook is much wider than the area that we'd used in the hills, we're talking a considerable amount of money. So I think you know that.
We do not agree.
Good. And I don't think it's a good idea for a lot of reasons.
Would it
Finally,
be possible to wrap up in a couple minutes?
yes,
Just thinking.
finally, the last thing is traffic. I agree with you. I live a mile west of the Boston Post Road. I also agree with a statement that one commissioner made that a lot of people ignore the right-only turn coming out of IGA onto Post Road. I think traffic is going to be a big issue here, and I hope you looked at it very carefully. Thank you.
Thank you. Is there anyone else from the public that wishes to speak on this project? Please state your name and address.
Of course. Good evening. My name is Conrad French, 3 Oriole Circle. I don't want to take too much of your time, very cognizant of the late hour as it is already. I'll just say a few words quickly on this planned development, proposed development. The first thing I really would like to say and emphasize is that there is a real need for affordable housing in Connecticut, not just southeastern Connecticut, but across the state. This project isn't that. Age-restricted affordable housing has been a guise for many years for developers to be able to say that they're implementing affordable housing, improving communities and standards of living for many folks, while restricting those opportunities to certain sets of folks. And unfortunately, that's exactly what this is. It purports to be affordable housing, but by setting an age, I believe 55 plus is the requirement, it takes on virtually none of the burden of affordable housing that's needed in the state of Connecticut. Most of that burden is among younger people and renters who actually the vast majority of whom are under the age of 55. And so for those folks, this unfortunately would do very little to combat the rising costs of housing in Connecticut. And to that point, I think the other thing I'd like to elucidate briefly is the idea of transparency. And I think any private entity that works with government bodies like yourselves and the general public like myself has a real duty to take care in being transparent in the way they operate. And I'm afraid that on a number of points that have been discussed tonight, that that's something that may be lacking in this instance. I think, for instance, I would just call to the Commission's attention the desire to, not necessarily even beforehand, but midway through a public hearing, try to reverse its status as a public hearing as an indication of a lack of transparency and potential intent. The other thing I would point out as well is, despite a stated commitment to expressing fully and openly all the information that would be useful for the Commission, there are also, as Attorney Carey pointed out, a few contradictions in a stated desire to achieve inferred approval for said project after 65 days. So noting, I think, just wanted to reemphasize for you all an attitude present that concerns me personally. And the other thing I'll get to is the environmental concerns, which I think, again, speak to a question of transparency. I think the idea of having a sod farm on what purports to be otherwise residential property is questionable, to say the least, and certainly commercial in its application, and would really have quite grave consequences for what, as was mentioned earlier, is a sensitive waterway, and important piece, it's an essential piece of the East Lyme ecosystem. I look forward to the opportunity to review further the materials that have been provided tonight. As was mentioned before, this is certainly no doing or fault of the Commission itself, but more open access to those materials on the part of the developer is something that would be great, and the opportunity to review those now is welcome. Thank you all.
Thank you. Appreciate it. Anyone else tonight? Yes, ma'am. Yes.
Just had a student teacher basketball game in college. My name is Amy Stoddard. I'm at 4 Oriole Circle, behind the 1940s barn that was purchased from Andrew Davis, who couldn't be here tonight, but he received the invite in the mail today. So I am here for not only the black bears that live behind my house on this property, the pack of coyotes, the fox family, the bobcat family, the wild turkeys, but for my friend who lived on the 13 acres this property, Peter Teitla. I took care of him during COVID, and we had to call 911 several times and have the fire trucks, the emergency vehicles come in and out of that area. And it took longer. It took longer than it should have. So this is an elderly person living on this property that we had to utilize those services. And going back and forth, taking care of him during COVID because no one else was available to go there. Getting in and out in that area, it doesn't even matter if it's 4 o'clock. People come whipping around from Route 1 off of 395, and I almost was hit several times, and I have faster reflexes than probably a senior population. So it's a really dangerous area, knowing it, going in and out of that area. I also know, because I was part of the signing of his will, that he donated this 13 acres to the East Lyme Land Trust. And I was there with the lawyer and the signing of this. So I'm not quite sure what happened. I do know that the president of the East Lyme Land Trust had befriended him at auto shows, and he was very adamant that this land was to be for East Lyme wildlife. And that's why he was connected for several years with the president, planning on how he was going to donate the land. And I was invited after this signing of the will, where he donated the land to the East Lyme Land Trust, and the house and contents was donated to the president to take care of East Lyme taxes that weren't paid and a reversed mortgage that the president of the East Lyme Land Trust, as a friend, was paying off this reverse mortgage. So they knew about those two things about the property. And then I was invited to be part of East Lyme Land Trust. I went to one meeting and was just really disgusted at the fact that the discussion was, we don't really want this property. And it doesn't fit any of the criteria of the properties that we accept to be donated. But this is now, he passed away, and now they're like, well, what do we do? We're going to try to find, different things we can do. I said, he donated the property. How can you figure out ways of trying to sell off the property or whatever? So anyways, to pay for all of the debt, there was a public auction. The owner of the property that abuts this property, the 13 acres behind with the 1940s dairy barn, this gentleman, Andrew Davis, won at the auction, however that works. And during the time of the auction, when all of the people were there, someone with a key went into the house and showed people around. And there was I guess he had already owned it or had already purchased it to pay off the bank loan. I don't know. I feel like this should be investigated, and I'm sure there's some loophole that made it okay. But like I said, I'm here for the deceased and the animals that he thought were going to be protected on this land. And that's all I have to say.
Well, thank you for speaking up.
Thanks.
Is there anyone else here tonight? Are there any last words from anybody before I ask for a motion to continue this hearing?
Just because I can't help myself, but if in terms of the date, that is probably the bigger issue, because I think I heard you say next Thursday. Mr. May has a commitment already for Thursday. And I'm assuming once you have a chance to review this, you're going to really not have a lot of questions for me. You're going to have questions for him and or design. So I'd like to make sure that he's available.
I don't think we can go much past. Jessica,
We could
do you
do
have the calendar.
I just looked at my calendar.
Tuesday or Wednesday.
Yeah.
I believe this room is occupied.
Because that's the 65-day we're looking
This,
at?
well, I was talking with Attorney Carey. We think the 65 days is probably April 2nd. But obviously, you're going to want some time to deliberate. And also, I'm assuming Mr. Mulholland's probably going to want to draft a motion or something, and I don't mean to speak for Mike, but, so there's time, we just have to be very cognizant of it.
Lawyers are notoriously bad with arithmetic. I think it's the 23rd, but it's 65 days from the 18th of January.
Oh,
So we could do it on the 21st.
Yeah, I don't want to be the one that is responsible for that date.
So what was the date in January, Attorney Carey?
My
The
understanding is
18th?
it was received officially on the 18th. That was your first meeting after it was filed on the 17th. So that means there were 13 days in January,
Yeah, so,
29 in February, 23 days.
so that's 7, 10,
23rd.
oh, decision date, that's when he's getting 60. Okay. Yeah.
And I
Be-
did think, I
right.
could be wrong, but I thought Mr. Mulholland had in mind to continue the hearing to next week.
I math may have been wrong, so 14 plus 20.
Regular meetings.
on the 21st, we have.
Yes. I think the 21st would be the very last date. Unless I counted wrong.
21st would be 64 days, right. Thank you, yeah.
Doesn't have to be on a Thursday.
Well, the problem is that you don't go over the room. I
Yeah.
have another room in the building that you could use.
We don't have one that has recording.
Are we imagining that we articulate the issues and they come back with a revised plan that satisfies the issues?
Not for the concept, I would.
Not
So
from,
we are, what's the problem with not waiting till the 21st? What's the rush? Why do we need extra time?
I think the idea was to finish the hearing on the next Thursday. Whatever day that is, 14th.
And I'm not available,
But,
So
but,
if we
I am
just take,
available on
but what are we being asked to decide? We're being asked to say yes or no to the conceptual plan?
correct.
Ultimately, you're going to have to make a decision.
On the conceptual plan?
Yes.
This plan?
Yes.
Before you have an opportunity to make any revisions to the plan, is that right?
Right, we wouldn't be making any revisions at this point, so we'd take, assuming you approve it, maybe you say you gotta address this, you gotta address that, then we go back and say, okay, but you either approve it sort of as is in the conceptual, or you might say there are some issues that we want addressed. When you come back, we'll approve the conceptual subject to, and, you
That's
know,
what I was imagining.
So we should be able to do it on the 21st.
well, that being the case, I mean, if we're just putting issues or thoughts on the record, as it were, without absolutely necessary that Mr. may be here, it'd be nice if he was, but
yeah, I just didn't know, I mean, I'm assuming if you have time to look through some of the materials and then go over the staff comments, would there be any other questions that you have that we would want to satisfy for you in order to receive an approval?
We could send our questions to Mr. May and he could come back on the
yeah, I think
21st.
we should,
Okay.
let's schedule for next Thursday with him or without him, and, you know, at least get our thoughts on
Okay.
the record. It seems that's what we're doing here, is establishing a record.
Yeah, agreed.
You could always cancel the 21st
Yeah.
but I think it's better to schedule it than with the option of canceling it if you decide you don't need it.
So a week from
I
today.
think
and
that's a
then
good
also the
idea.
20th.
Does someone want to,
First meeting,
And just keep in mind, there is a traffic report that was pretty extensive, but I think would have answered a lot of people's questions
Okay.
if they had read it about the safety, because it was addressed in there. And then, of course, I'm bound by design elements. It would be great if I can do, solve world peace, but if we could keep it into the design elements or the design criteria that
if you could just make that a condition of the approval,
world
that
peace.
he solves world peace.
Don't say, hey,
I think because it's a conceptual review, I think we can look at it next week without you here. We can forward questions to you and then we can just still discuss it on the 21st.
Okay, that would be wonderful. And I just want to, the last person's comments about the tightlet thing and the, you know, something untoward happening and all, he had a reverse mortgage on the property, the bank foreclosed on it, and it went to judgment. That's why it didn't go to the land trust. That's why my clients ended up acquiring it. There was nothing untoward about any of that. The land trust wasn't going to pay off a $290,000 debt. They didn't have the money to do that. So that's where it went.
We have so much to do tonight.
I know, and
Can
I'll
we
shut up
have-
with that.
Thank you, and thank you for everyone coming. Could I have a motion that you want to continue this?
Make a motion that we continue the hearing to the 14th of March.
Is,
Second.
all those in favor say aye. Aye. And let's take like a 3-minute break, please. Okay, let's keep on moving here. We're moving on to the regular meeting and the approval of minutes of the February 15th meeting. You sure can. Does anyone want to second that? All those in favor say aye. Aye.
Aye.
I think 6-0-0. Moving on, the next thing on the agenda, and I know Mr. Peck is recusing himself. For now, let me just read what we're doing. It's the continuation of application of Bride Lake LLC for site plan approval for the modification of the December 3rd, 2020 approval of an 80-unit affordable housing multifamily residential development pursuant to Connecticut General Statute 8-30G, increasing the total unit count to 100 multifamily units on the westerly side of North Bridebrook Road, 20.24 acres, now Bering Street, number 94, assessor map 9.0, lot 37-2. Mr. Peck has recused himself. Ms. Sesko, have you reviewed all the materials and the videos? Do you feel comfortable sitting in, or it's up to you if you've reviewed everything?
Yes.
Oh, okay. Then did the applicant's attorney want to speak?
Public hearing is closed.
Okay, yeah, no, he had a point of order, but, well, let's move on. I do have a memo just about process. Just to remind people, if anybody has gone out and walked on the site, our town attorney just wanted to remind us that members cannot rely upon facts learned from a first-hand investigation without giving the parties before them an opportunity to rebut the evidence. Site inspections must take place before the public hearing is concluded. So that's just that's an opinion from our town attorney to keep in mind. So do we want to have a discussion first? And just a reminder, if a motion is made to deny, you have to state the reasons to deny before we have a second, because with an 830G application, you have to address the things, those 4 issues that we were given by the attorney that are listed. And I believe we were given pros and cons to look at tonight. And again, we can continue this till next week. But we can look at the approval and the denial. Again, if there's a denial, you must list that the public interest must outweigh the need for affordable housing in the community. And we're all aware of that. So I don't know if you want to have the discussion first. We can continue it to next week. Someone can make a motion now, then discuss it. it's up to the commission.
I'd like us to have some discussion before we figure out if we're continuing it next week.
Yeah, I think that would be good.
Yeah, I mean, first of all, I'm trying to understand procedurally. You know, let's say we, you know, formulate a general opinion that, let's say, we'd like to approve it with certain restrictions or conditions, right? Is that then something that we'd want the motion written by the staff or town attorney thoroughly and convincingly and legally? Right, so.
Well, I think there are conditions in here.
And then we'd take what they write at, let's say, the next meeting, and we'd have a motion on it, right?
We can do that.
He has a couple of drafts here. Did you, if you've had the chance to look
Yeah,
at
I'm
it?
trying to find them in the pile of paper, but I can't really.
Towards the bottom.
So these large print, bold-faced documents.
Do you want to take a minute for everyone to look at those?
Under new business, is it? Under site plan?
Under
Oh,
Bride Lake LLC, Affordable Housing Site Plan Modification.
yeah, there it is. I see it. So that's the, where, oh, I see, that's the whereas stuff. Okay, thank you.
So why don't we take a couple minutes to read through these
Okay,
and then have a discussion?
okay.
Can we talk while we're
Yeah,
looking
yeah,
at these
let's
things?
go.
So I keep coming back to the same thought, just in big picture. There's 80 units already approved. The application's for 20 more. And I understand the objections, particularly having to do with water runoff, but I haven't heard anything from any of the rebutters or any evidence that shows that the extra 20 units is going to make a difference. And given that, I mean, I'm inclined at this point, unless I hear something, you know, persuasive, to approve it, and I'm content with the language in the motion to approve that Mr. Mulholland drafted.
I am in agreement. I know we had a third engineer pop up at the last minute, but the report he wrote, he didn't come to defend it or be cross-examined with it. He did not go to the site before he wrote it. So I tend to put more weight on our town engineer and the applicant's engineer that spend a lot of time going over it with us.
And that report had to do with the project as a whole, not the additional 20 units. I mean, he was addressing the whole package, not just the addition of the 20 units. That's what's in front of us. So I mean, even if he was right in that report about every aspect of it, the extra 20 units isn't what kicks it over the edge.
I personally feel like if there was a lawsuit, it's not one the town would win, and I think people's tax money, I hate to spend it on something that we could not win and would get built anyway. That's just my opinion.
I agree.
I have a different point of view on that. I think that we're being asked to approve the amendment to the site plan. And the amendments to the site plan seem to me to be an addition of 25% more units, as you say, but also a change in the stormwater management system. The stormwater management system that is proposed is as we saw on the record and what the Mr. Heller and the engineer for the applicant said is a substantially different system than the one that's in the original site plan. And so that causes us to say, well, what about that? Now, if it was just a matter of adding 25% more, water discharge to that amended system, which, as far as we know, is going to work perfectly fine and handle that 25% more housing units, that might be okay, because that's what we all want, is to protect Bride Brook and the groundwater and Bride Lake and the estuary and the beach. But the problem is that we have Mr. Trinkhouse, and we have substantial evidence in the record that brings into the question the effectiveness of that system. To quote Mr. Trinkhouse, "There will be premature failure of the stormwater system. The system does not reduce non-point source pollutant loads. Many aspects of the stormwater basin are not in compliance with sound engineering practice or the 2004 or 2023 stormwater quality manuals. The forebays and the retainer cell will infiltrate pollutants directly into the sand and gravel soils, which will not reduce pollutant loads. Infiltration from the rain gardens will be minimized or eliminated due to their sloping design," and so forth. So this is, as you know, it's an extremely sensitive site because of its proximity to the Bride Brook. Not just because it's near Bride Brook, but because Bride Brook is already overloaded with pollutants that exceed the allowable public health standards for E. coli, as well as the pollution standards for E. coli as it relates not just to public recreation, but also to fish and wildlife. And that directly contributes to the regular closures of the beach. And so when you put a project like this, on site, the original 80 or the next 20, you've got to make sure you have an effective stormwater management system. And so what we have is, one engineer who says it's not going to work, and another engineer.
Two engineers that say it will.
Another engineer who said, I disagree. And so we have to then make a judgment about what we do about that. As far as I can tell, I looked at Mr. Hadfield's rebuttal of Mr. Trinkhouse's critique very closely. I read it and listened to it. And I was ultimately left unconvinced that Mr. Trinkhouse was wrong. For example, he said that the forebays are 2 to 4 feet too shallow, and cited the 2004 water quality manual for backup, indicating that they'd be too shallow. You'll remember he said because they're so shallow, when you get a big storm, the sediments that had been collected will be resuspended in water and discharged into the system, causing problems and so forth, as far as I understood his argument. But Mr. Hatfield then said that, but the extra depth really does nothing. But he offered no manuals or research to support his claim other than his own opinion. Mr. Trinkhouse is pointing to the water quality manual. Mr. Hatfield's pointing to his own opinion. That leaves me more skeptical of Mr. Hadfield's view than Mr. Trinkhouse's. Why would the 2004 water quality manual recommend 4 to 6 feet if it wasn't needed? And I can go over the other arguments and the rebuttals against those, but I think I've made the general point. And lastly, so if they're both, equal in qualification or have equally persuasive arguments, you still end up with the possibility that one is saying that there's a likelihood it's not going to work, and we're going to be ending up worsening the pollution that we're already having to deal with the closure of the beach and so forth and so on. And so, you know, when you think about it that way, from a precautionary point of view, it seems to me we should be erring on the side of being more careful.
And
so what that, yeah, I'm sorry.
Did you read this right here? The condition that was put in the back?
Yeah, yeah, it's not totally clear to me what it means, but that leads me to my point really, which is I really don't have an interest in denying this project on this particular ground, for example, but what I do have an interest in is resolving the debate over whether the system as proposed and designed is really going to work or not. And I'm not. I feel that's we should. You know, that'd be the. I feel that's my obligation and responsibility to see to it that we're. You know, we're going to get a system that works. So therefore, I really would like to see the parties. I would like to see Mr. Hadfield and Mr. Trinkhouse, for example, sit down and have this discussion, and really discuss whether or not what his concerns were, and sort it out, and see if we can't. Get some design revisions or persuade Mr. Trinkhouse that all is fine, it's going to work just fine. But one way or another get to a plan that is supportable with respect to the water quality.
Wasn't that requested at the last meeting? There be a meeting between the two?
Perhaps, but I don't think it happened.
No.
And so that's, you know, that's where I'm at. We still have, I don't know, some 50-something days before we have to take a decision on this. So there's time to sort this out. But, you know, and then, you know, so I feel like with respect to those tests, the 4 tests we have to, you know, prove, there is sufficient evidence in the record because I think because we have a clear statement from a real bona fide expert, this Mr. Trinkhouse.
If why wouldn't he come and be cross-examined, and why wouldn't he go to the site? I mean, it's hard to put a lot of weight into just a paper you read. When he hadn't been out there, he wouldn't come and be cross-examined by the applicant. It's just hard for me personally to throw a lot of weight into this guy that popped up the last minute.
And he was hired by someone who opposed the project.
Yes.
And I believe that can color the attitude that you approach a project with.
Well, you know, he was hired by someone who was concerned about the water quality issue. That's true. Mm. But like me, doesn't necessarily oppose the project if the project is satisfactory vis-a-vis these environmental impacts.
I get your point, and I'm not crazy about this project either. If I'd been here 3 years ago, I probably would have opposed it for just these reasons. But even if we turn this down, there's still 80 units going to get built with the system that they've designed and has been improved. And so we'd have no more to say about it whatsoever.
That's why it's, yeah.
So I keep coming back to the idea, is this 20 units going to make that difference? I'm not sure that that's the case.
Here's the way I would think about it at the least, which is that if the stormwater management system is not doing all it should be doing and is adding pollutants to the river system, the water system, which is already polluted, and I'm talking here particularly about the E. coli problem in particular, but there are other problems, pollution problems too, that we can, you know, anyway. Then we're being asked to increase that pollution level by 25%. And that, to me, is, you know, adding damage on top of existing damage that's going on. So even if, so what I'd rather see is in exchange for the 25% increase in allowable units, I'd like to see a resolution of this and fixes if necessary, or the satisfaction by Mr. Trinkhouse that the system is good. I don't think he's got an axe to grind. I think he's an expert who looked at the plans and pointed to the water quality manual and said, you know, Floor base should be 4 to 6 feet. There's going to be percolation directly from them into the water table that's going to, allow pollutants to get there and so forth. There are certain things that need to be fixed in the system, is what he's trying to say.
Could I make a suggestion, just because of the time frame and we still have things to do? Since this does not have to be voted on tonight, we could also, we're having meetings every week for the next 4 weeks, it looks like. So we could very well continue this until next meeting, unless you want to vote on it tonight.
We don't have to. I mean, if Mr. Trinkhouse is going to be involved going forward, somebody's going to have to pay him.
Right.
I'm not going to pay him.
We don't
No.
have a budget in some.
Well, the town, look, the town has a $60 million budget. And I don't know what the state of Mr. Mulholland's, discretionary cash is.
It's very small.
The work he did costed $500, because I asked her afterwards, or she said so. It's just not, we're not talking about a lot of money to facilitate a meeting. And if it wouldn't be him as the third party, perhaps it should be somebody else, such as people from the firm of Fuss and O'Neill, which are quite expert in this kind of thing. They have to be paid too, you're right. When we get a really, world-class expert saying this is not going to work, I think it's worth the $500, the $1,000, the $3,000. The town should cough it up. If I need to go and encourage the first selectman to find the money in his discretionary funds to do this, I would be happy to try, and I'm pretty sure he would spend the money. What I'd like to say is I'm not trying to vote this project down. I'm trying to get this stormwater system right. And so that's one of my two concerns. I also remain very concerned about the public safety associated with there being no sidewalks. There's going to be a lot of kids on this project. We're going to add more, and they're going to be having to walk in the street. And if you add up all the walking trips that are likely to happen, there's literally going to be 10, 20,000 walking trips a year on that site.
To where?
All around the site. People going to their cars, people going to the...
Within the site, you mean?
Within the site. People walking their dogs, people taking a walk, people going to the mailboxes, people going to the playgrounds, people going to the school bus stop, et cetera, et cetera. People visiting their friends. And then, there will be some that will walk the, half a mile, quarter mile or 2/3 of a mile down to the park and the bar and the state park. But no, a lot of walking around on that site. And let me just tell you this, there is more risk of being killed by a car crash off-street in this kind of a setting, according to the national statistics on this thing.
I think we have to be careful not to add any evidence, because
this is not evidence, this is just my own knowledge from my expertise in the field. Let me just make my point. There's more of a risk to that, to the pedestrians here, than there is of dying from a fire or from a natural disaster or from a flood. But we take care to make sure those things are addressed in our plans. We ought to be taking care to make sure that people are safe, the kids are safe in the sidewalks. And last thing I just want to say is, I'll say it very, very quickly because I know the time is late. Number one, with respect to balancing this, the test of balancing it against the need for affordable housing, that is a test to apply to the local housing requirements. Our affordable housing plan is very clear. We have a surplus of 600 apartments in the range of in the price range that these affordable units are going to be providing. And this is not, and we have a need for those that are like 1/5 to 1/3 the rent. That's where the real need lies, and this is not going to be providing any of those. So this business of does this public interest that we're talking about, protecting the swimmability of the beach and so forth, against the affordable housing need, it's a no-brainer. That's not a difficult case to make. And so I'm not in the least concerned that we can't make this case if we wish to.
Ms. Markovitz?
Yeah, I mean, we haven't had a citizen concerned enough to spend our own money to have this study done. And I think we certainly have time to talk about this, to think about it. I appreciate Gary's willingness to go to the first selectman to see if there are discretionary funds. We can't horse around with this. This is like environmental, and the people who put us here, the citizens of East Lyme, are concerned. And that's all I have to say.
Ms. Sisko, do you have anything to say tonight?
I do think it's worth pursuing some more information from Trinkus, because it is an opposing view of the engineering of the stormwater. And this as-built site plan, is that a change to what was presented to us earlier, or no? This
It's the plan that came the second part.
at the second part, and they're going to.
They incorporated some of the changes that were suggested in the first part of the public hearing.
Okay. That is all I have right now.
Well, someone could make a motion, or we could just continue this. I personally have a problem with this Mr. Trinkus.
I'm surprised to hear him described as a world-class expert.
Well, I can tell you that he's practiced all over the world, doing consulting on low-impact development and stormwater management systems. I mean, this is from his bio. He was the chair and the primary author of the American Civil Engineering Society's committee that created a national model ordinance on low-impact development, stormwater management
Is
systems.
this someone you've known from a previous?
No, I've just read his bio because I was trying to say, well, what's the value of this guy's input? Can we rely on it? Is it useful? And you have to look at his qualifications. And so, we also know that, engineering, none of us are all of us are fallible, none of us are infallible. And it's certainly possible that there could be disagreements, and one of them could be right, and one of them could be wrong. But he's done a lot of this work for lots of communities in Connecticut. He's a real major player in this field, so yeah, credibility matters.
If you could actually find the money to bring him back, I would almost rather hear from a third party. We've already got the opinions of two experts who disagree with one
You mean a
another.
third party, yeah.
Yeah, someone new.
Well, like Fuss and O'Neill, for example, Fuss and O'Neill is the big company, very highly regarded. They literally were the consultants on the 2023 Stormwater Manual, and they also wrote they were the consultants on the Nyack River Watershed Management Plan that was raised earlier.
Yeah, I mean, I have no objection.
They're solid.
I have no objection to that.
And you could say, look, you two, you could do it that way. Yeah.
I'm happy to talk to Mr. Cunningham to see what's in the budget, if that's what the consensus is of the group.
It's okay with me.
Yeah.
Okay, let's do that and move on.
And just so you know, just want you to know, I'm not inclined to vote for the project without any solution to the pedestrian safety issue.
I think we understood your point.
I didn't want it to be implied that we solve this one thing and it's all fine. But those are the two things that I'm most concerned about. Okay, thank you.
Okay, yes. Under all business, we had a subcommittee night. Oh, if you could switch places, thank you. We have a subcommittee, and I understand Mr. Peck and Mr. Mahalan met and are working out a schedule for outdoor lighting. They're also working out a schedule for mixed use in the CA zone. And Attorney Bleasdale is really coming one of these weeks to talk about affordable housing. Under new business, we do have an alternate vacancy, and because of the state law, it needs to be actually a R or an unaffiliated. And we did get a very nice letter of interest from Mr. Liska, who's here tonight. Would you like to stand up and say a little something?
Thanks for applying.
I don't know, boy, it's not tonight. So, my name's Jim Liska, 11 Legendary Road, East Lyme, Connecticut. Hopefully you guys got a bio from me.
No,
Yes.
I'm afraid not.
It's in your packet.
If not, I will talk about myself and we'll all be surprised.
Please do.
So, rather than me tell you, anything about me that's not in the bio, I was elected in 2010. I was on the zoning board till 2021, and I lost my seat. So here I am. But I'm reapplying for an alternate and asking for your vote. But you know what might be interesting is maybe you want to see, hey, what did I observe tonight? And ask me questions about that and see if my opinion would match what you think. And then you can say, hey, this guy kind of sees things the way I do, or I'm off base and I'm not somebody you want.
Jim, you're the only applicant. Let's not.
Yeah, so I am, and I could say I do come to the meetings. I do pay attention. I do like being an alternate, and one of the things I did get a chance to say is, hey, when those attorneys are passing out the paperwork, make sure you ask for a copy, because really any of us can be sick or need to recluse ourselves. And I feel the alternates play an important role to support you guys, because if there's somebody as an alternate, then you can recuse yourself. You can step down. I think 10 years, and one of the things I would like to add is that, one party brought a specialist that was talking about road safety. I do know from the past is that if the zoning board didn't have an expert opinion counter to that, it kind of, you just had one side of it. Some of you guys might think, like, at 35 miles an hour, what is that? Well, it's 50 feet per second. So if they're saying it's 300 feet line of sight, that's 6 seconds to see traffic and make a decision. Maybe some of you know that corner and you'll say it's a lot less than that. So maybe it's significantly less than 6 seconds, but without somebody, in there. So that's the kind of stuff I bring, is some history to just say, hey, have you thought about this? And I see that's what you guys are doing. And I think that's healthy, to have that opinion, to say, well, I think this, and somebody else says, well, I think that, because that's how you come to your consensus, and that's why we have sometimes a 4-6 vote, or 3-3 vote, or something like that. So, Jim Liska, I'm asking for your vote, and I'd be happy to answer any questions.
I'm good. Okay.
Just a curiosity, what's your professional background?
Yeah, so,
or whatever background.
Yeah, I'm a manager of clinical engineering. So I was at Lawrence Memorial Hospital. I started off as a biomedical technician. That's somebody that repairs medical equipment.
Oh, yeah.
I did that from 85 till 2000. In 2000, I applied for and was accepted as a manager of clinical engineering, and I was at Lawrence Memorial. I was there until about 2014, when Lawrence Memorial acquired Wesley Hospital. I managed both hospitals. I did that till 2023, and I was promoted to the manager of Yale New Haven. So I now oversee clinical engineering for York Street campus, which is Yale, and St. Rayfield's campus. And collectively, they're either the 5th or the 2nd largest hospital in the nation. And it depends on how the beds are counted, but they're one of the top. So all the medical equipment under there comes under me. And I will tell you that I was there at 8 in the morning, and I struggled to get to this meeting for 7:30 at night. My days are that long.
Wow.
So this is not something I take on lightly. So.
Thank you.
Thank you. I move.
Can I make a motion that we accept Mr. Liska's very nice application?
Somebody must have rewritten it.
I'll second that.
Thank you.
Okay, we have a second. I just want to say I worked we worked together on zoning for probably, what, 4 years or more?
Yeah,
And
your
I
first
can definitely
selection. Yeah.
vouch for Mr. Liska.
Yeah, we were alternates together.
Yeah, yeah.
In cheap seats.
Yeah. Can we have a second? Any discussion, or do you want to?
That was a second, I believe.
Yes. Okay. All those in favor say aye.
Aye.
Opposed? 600. If you could go to the clerk and get sworn in before the next meeting,
See you next
which
Thursday.
seems to be next Thursday. So go see Karen. Thank you and welcome back.
And on that, Brydebrook, does he have to now read and go over, and how's that work when you're brand new? And
I may have to recluse myself from that because I wouldn't be familiar.
Yeah, all right.
You know, and it would
Quite.
probably be from this point going forward.
This point forward, yeah.
But I would, sorry.
No, that's
okay.
right. No.
I would recluse myself because I wouldn't have information to vote. If somebody were sick, we could go with, unless you were here.
There's
we could go
two
with-
others, yeah.
Quite honestly, if Miss Uhas is back next time and she looks at what happened tonight, she'd probably be the one most appropriate to sit.
Okay, thank you.
Let's see. We have coming up the application of Mr. Teropoulos for architectural design review for a small addition to property located at 167 Main Street, Niantic, Assessor Map 12, Lot 84. The staff will look at scheduling that. Any business on the floor?
Excuse me.
Yes, Norm has
What
something.
happened to the Kristen Clark application?
Oh,
Continue the public
it's,
hearing.
since it was continued, there's no sense of having it in the regular meeting. It's continued to next time.
That's right. I do have a couple of items. in front of me.
Okay, go ahead.
First, in regards to the CA zone implementing the design guidelines,
Mhm.
or not guidelines, the design restrictions. Bill and I did talk about it. The committee has not met yet. We've got to schedule a meeting. Bill's going to send out an email. But as one thought I did have, I thought I'd bounce it off. The object was to eliminate the new mixed use, thereby reducing the chance of the tearing down of the older buildings in town and replacing them with apartments upstairs, retail downstairs. Since Flanders Road has pretty much been demolished and redeveloped, there is very little, if anything, left to save, or worth saving. So I suggested to Bill that we form a new zone called CA1 or something like that. Have the same regulation as CA, with the exception of mixed use exclusion. That was the thought.
Norm, where would the line be between CA1 and CA?
Boston Post Road.
Would be what?
CA
So the Flanders Road and
would remain CA.
would remain CA, and it could have mixed use, and then
Yes.
CA1, Boston Post Road,
Yes.
would not have.
Yeah, Boston Post was
mixed
really,
use.
really the historic part of town.
Yeah.
That was developed before anything else.
What you're suggesting solves my concern about what originally, which I was concerned it was painting too broad a brush with where you can't do mixed use, because I thought there were areas like on Flanders Road where mixed use might be appropriate. And I also think from Four Corners on Boston Post Road to, let's just say, the school, where there's 1960s and 70s stuff, some of that could also be, could benefit possibly from mixed-use development projects. It's just when you get past, get to the school and the church and onward from there.
Well, you can't spot zone, and there are old houses from both ends of the CA zone on the post road.
Yeah, no, I'm saying don't spot zone. I'm saying the CA1 you have in mind.
Yeah.
I'm just suggesting we would start it on Boston Post Road, after, let's just say, the Dollar General, and go from there. So that
there's houses that are significant to the west of Dollar General.
That's right. We're agreeing on that. That's what I'm trying to say. And so they could not be subjected to mixed-use development that would eliminate them. That's what you're proposing, yeah?
I'm proposing Boston Post Road.
Where you could do no mixed use.
Right.
Right. I'm just saying, from Dollar General onward toward Four Corners, there are sites where mixed-use development could be appropriate. That's what I'm trying to say.
You're getting into spot zoning, okay?
Why is that? Because you get all the way, it would be connected to the existing zone that would go on down, go down Flanders and up toward McDonald's and so forth.
There's a couple of nice structures down to the way to the east, almost to Waterford. The old mill,
Mm-hmm.
2 houses from 1800s.
Oh, by Golden Spur?
Yes. So that's.
So you're concerned about protecting them as well. So that's why you'd have the whole Boston Post Road not have.
Yeah.
Yeah, I understand.
Anyway, item number 2. Bill and I discussed, I think this was brought up before, the requirement for the design districts, which CA will be also hopefully someday when we get that presented. Currently, it requires the words shall hire an architect to guide the design. Well, number one, the town doesn't have any money for an architect if he wanted to do this. 2, the proposal would be change shall to may. This gives us the flexibility at any future time to install and hire an architect. Currently, we have a zoning official that I trust impeccably in this regard. He has done a great job in working with developers over the years and producing good-looking buildings in most cases. Sometimes you can't penetrate the heads of developers, but he's been able to do it most of the time. So while we have him, insert the word may, so that at some point, when Bill's not here, we might need an architect. And we can budget it, put it in the budget.
I agree with that. I know the original intent when that was put in was to get one when you needed one. I'm not sure how it came across with shall, but I don't think every tiny little project that could come to us would need an architecture. Yeah, I think
this is substantial improvement.
I think May is a great, because then you have the opportunity to hire one when you need one, and if the commission wants to vote for that project to get one, but for other projects you wouldn't have to. And again, I know there's not a lot of money for that.
If we're okay with that, I'll call Bill and tell him, present it, we'll have a little public hearing and pass it with one word.
Does anybody else have Mike or Nancy?
I think it's appropriate. To make the change.
Well, I'll be the lone voice and say that I don't think it's legal to do that because the state statute, that language comes straight out of the state statute, which provides for the what do they call it? Town, small town, rural.
Bill did check
village
that.
district, yeah.
Bill did check that, and he says it can be done. We can do this.
I'd like, well, okay, I'll ask him how, because it's pretty clear the statute says shall, and it gives some other options.
Can we, I'd like to make a motion to present this, subject to Bill's double checking on the legality.
Second.
We have a second. All those in favor say aye. Aye. Opposed?
No.
5-1. Thank you. Anything else?
So even though Bill's going to check it, that's still not, you're against it for some reason.
Yeah, I do think, I mean, if I'd had a chance to, I would have said that I think that it's a good idea to have a design expert on especially larger projects. And I don't think we should leave it to the commission's discretion to make that determination. I think it's good medicine.
I don't think you've been around long enough to witness Bill, what he can do, what he can produce, what he can get developers and builders to do. And he's come up with he has a good mind for design. He really does. That's why at this point in time, I don't think it should be as an option. But I'll have him check the legality.
Okay, and let me just say one other quick thing, which is that we can come up with the money if we want to by having the consultant fee, pass-through fee provision that we've discussed before approved by ordinance by the Board of Selectmen. And so it doesn't have to come out of the town's budget. It could be part of the application fee as a pass-through.
Even if we could have the money, I don't think the time and meetings involved for some of the very small projects really warrant an architect, but that's my opinion.
Just like to say that a lot of times when like if both sides were to dig their heels in, there's like their legality and what the state standard says, and sometimes it's that, you know, that kind of give and take and a little bit of talk that's led us to get to the seaside feeling that the town goes for, and the reason that the downtown looks so good. And it really is that it's sort of a camaraderie, and they work together. One of the projects, and I'm not a huge fan, but the storage building that's over by the Brybrook Mall, they tried to make it look like barn doors. They did come up with that blue look, which I don't think anybody really loves, but that whole barn look to try to make it look like it fit in like it was a barn, that wasn't a legal requirement, but that was something that the board had asked and Bill was able to get.
Yeah.
So like I kind of understand where he's going with that.
We really need to move on. I'm sorry. Comments from the ex officio.
Oh, I just had one quick thing before we, I think given the fact that we're going on 11 o'clock here, we ought to really revisit the time these meetings start, because every other commission starts at 7. We're the only one that starts at 7:30. Not a decision to be made tonight, but it's really something I think we ought to think about.
Okay, moving on to ex officio.
I think I can stand up. Good evening. You're holding true to tuition. Last night's Board of Selectmen meeting lasted 3.5 hours, so you know, you're fitting right in. So basically, it's all budget hearings, budget representations, trying to keep hopefully the bottom line down to a reasonable level, but there are lots of needs. There's lots of wants in town, but there's also a lot of needs. And so the question is, as always, what can we afford? You know, speaking of the average taxpayer, there are obviously some that can afford more, but try to build it, make it towards a reasonable as possible tax rate and tax increase and still get what we need to get done. We had hoped to put in some money to be able to get some additional help for grant writers. Very oftentimes, grant writers, once they find the grants, they can get partially paid from the grant, which would not cost us a great deal of extra money. And certainly, there's lots of grants out there that are available. You just got to find them and then make sure you can make the criteria. So a tremendous number of requests, and we're plowing through them. There'll be a public hearing coming up within the next couple of weeks for community input, and there's going to be some disappointments because we just can't fund everything that's asked for. In regards to the most recent discussion, Mr. Pivo suggesting that he would go to the first selectman. I believe that Mr. Mulholland should not be bypassed. He is,
Definitely, yeah.
He's your your advisor, and if Mr. Pivo wants to encourage Mr. Mulholland to be included, and then the two of them wish to approach the first selectman.
Yeah, and I've already stated, yeah, I'll take care of that, so. Okay. Thank you.
Any questions?
No, I think we're
I might be the briefest person of the evening.
We're winding things up, and I think, Ms. Sesko, you went to the planning meeting? Oh, it still hasn't happened yet. Okay. And I think, anybody want to move we adjourn? Second. All those in favor say aye.